You guys ready to go? Good morning, everyone. I'm Lieutenant Governor Kim Driscoll, and I would like to welcome everyone to the hearing on the nomination of Gabrielle Wolohojian to the position of Associate Justice of the Supreme Judicial Court, our administration's second nomination to the state's highest court. As we begin today, I'd like to first recognize Counselor Marilyn Petito Devaney, who represents the nominees district, to introduce the Governor's Council, offer her own words of welcome, and read the letter of nomination. Councilmember Devaney, should just get you. Go.
Thank you, Lieutenant Governor. Good morning to you, to Governor Healy, members of the Governor's Council, and to everyone who is with us on this special day. There are many familiar faces and distinguished guests here who I am so pleased to see. I extend a warm welcome to members of the Supreme Judicial Court, Chief Justice Green, members of the Appeals Court, other current and retired members of the state judiciary and the federal judiciary, many court staff, court officers, and clerks. Bob Fisk, former United States Attorney for the Southern District of New York. Anthony Bassamian, co-chair of the Armenian Assembly of America. Welcome, of course, to the nominee, Appeals Court Associate Justice Gabrielle Wolohojian. And also, I'd like to say it's been 16 years since I had the pleasure to preside over this nominee. 16 years. She lives in my district. So it's a pleasure to be here with the Lieutenant Governor on this day. So she has deep family roots in my district, and it's a proud Armenian community. So it is my honor this morning to read the governor's letter of nomination. Do I have it? Yeah. Thanks. Dear counselors, I am pleased to nominate Gabrielle Wolohojian to the position of Associate Justice of the Supreme Judicial Court. I submit the nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I am enclosing the nominee's resume for your convenience. Sincerely, Maura T. Healy, Governor, Vice, the Honorable David A. Lowy. So with that, I'd like to introduce my colleagues on the council. Councilor Joseph Ferrara.
Good morning.
Councilor Iannella.
Good morning.
Councilor Duff. Councilor Kennedy.
Good morning.
Councilor DePaula. And Councilor Jacobs. So that'll turn over to you.
Thank you, Councilor. Thank you, Councilor Devaney, for your words of welcome and for your graciousness in sharing with me the honor of chairing this important hearing. I'd also like to extend my own warm welcome to the many distinguished guests who we have in attendance. Thank you to Bob Fisk for joining us. Bob Fisk, as many know, oversaw the Whitewater investigation and is a former United States Attorney for the Southern District of New York. This is not the first time the nominee has come before the Governor's Council. Gabrielle Wolohojian is one of our state's most experienced appellate judges, having served as an Associate Justice of the Appeals Court for the past 16 years. She first came before this body in 2008 when Governor Deval Patrick nominated her to the Appeals Court, and the Governor's Council voted unanimously to confirm her to that seat. At the time, Governor Patrick predicted Gabrielle Wolohojian will share with the Commonwealth her true love for the law, passion for life, and vast expertise and experience in complex litigation. One of her courtroom opponents, Jonathan Albano, who later went on to serve as the president of the Boston Bar Association, said, and I quote, there will be tremendous public benefit to having her on the appeals court. She is brilliant. With the benefit of hindsight, it is now pretty clear that Governor Patrick, Mr. Albano, and the Governor's Council were right in 2008. Justice Wolohojian's talents as an appellate judge are widely known and celebrated. I've been fortunate to hear from lawyers, judges, community members from every corner of the state reaching out to express their admiration for Justice Wolohojian and their support for this nomination. I can hardly do justice to all of what they have told us, but I would like to share some of what we have heard. Retired Justice Cynthia Cohen of the Appeals Court, who worked with Justice Wolohojian for 9 years, wrote to express, and I quote, her enthusiastic and unqualified support for this nomination. Justice Cohen describes the nominee as uncommonly kind, generous, and hardworking, with the intellectual firepower to unscramble even the most difficult and complex cases. Justice Wolohojian, Justice Cohen writes, is a judge who cares deeply about the courts, a person of wide-ranging knowledge, and a truly exceptional candidate for appointment to the SJC. Retired Justice Francis Fecteau, who worked alongside Justice Wolohojian for 7 years, wrote to share his view that Justice Wolohojian personifies judicial temperament by her calm demeanor, patience, respect, and consideration of all whom she encounters. The state, he writes, is indeed fortunate that a person of her competence, integrity, and skill wishes to serve on the SJC. Retired Justice Peter Agnes Jr. worked alongside Justice Wolohojian on the Appeals Court for 9 years and has continued to work with her on judicial education projects in his current role as the Chief Executive Officer of the Flashner Judicial Institute. Justice Agnes writes, Justice Wolohojian's thoroughness and insights about the state of law and its trajectory impressed me from the beginning. He continues, I believe without reservation that Justice Wolohojian is an exemplar of an excellent judge. And he concludes, Justice Wolohojian is a consensus builder who would bring her service as a justice of the Supreme Judicial Court a deep respect for precedent and tradition without being hamstrung by it, a willingness to compromise when it is the most effective way to make progress, and the courage to be bold and not to retreat to the status quo when the occasion calls for it. In addition to hearing from judge after judge, we have heard from Justice Wolohojian's former colleagues in private practice. One commentator wrote to say that what distinguished the nominee is her kindness and humanity, her ability to always remain grounded, and her profound empathy for those around her in need. In his words, whether helping a local unhoused person or caring for someone who has lost a parent or a spouse, Gabrielle's help is immediate, self-effacing, quiet, tangible, and practical. Her disposition is to put herself to work, to make herself useful, and to support and improve her communities, both small and large. To say that Gabrielle is a rare person is an understatement. I know of no person with greater depth of character or integrity. I won't read or refer to every letter we received, I promise. But there are 2 more that I want to share. Cheryl Riley, a friend who met the nominee while working as staff at a local law firm, writes, Dear counselors, it was Abraham Lincoln who said something to the effect that the better part of one's life consists of our friends. Judge Wolohojian's friendship of over 20 years is indeed associated with the better parts of my life. I am not alone. There are so many from all walks of life who value her highly and are the better for having known her. Justice Wolohojian loves life and all that it has to offer, be it her music, art, scratch cooking, and at one point, even tap dancing with a troupe made up of secretaries at the office. She is funny, loves laughter, and engages in quality bantering that keeps you on your toes. She will knit you a pair of gloves, help you paint a room, make you homemade bread, create holiday decorations together, and debate the issues of the day over tea. Then she'll hop on her bike and pedal off to embrace with grace whomever and whatever the day should introduce. In short, she is, without a doubt, the most remarkable person I have ever known. And finally, from the Armenian Bar Association. Dear counselors, this past week was momentous for the Armenian Bar Association because one of its long-standing members, Justice Gabrielle Wolohojian, was nominated to fill an open position on the Supreme Judicial Court of the Commonwealth of Massachusetts. We could not be more proud, and we enthusiastically support this nomination. Not only is she an outstanding, well-qualified, and hardworking nominee, clearly someone who would do an excellent job in this position, but if confirmed, she would be the first female Armenian justice to serve on a state Supreme Court in this country. This is a huge accomplishment for her and validation for countless Armenian grandparents who survived the first genocide of the 20th century, relocated in American communities, including in Massachusetts, and encouraged their children and grandchildren to work hard, contribute to American society, and give back. In the entire Armenian community, not only those in Watertown, Waltham, Belmont, Arlington, and Cambridge, but those in Worcester, Whitensville, Andover, Chelmsford, and Methuen, is quietly delighted that one of their own has received this nomination. Thoughtful about positions she takes and methodical in how she reaches her decisions, which I'm sure you can tell from her opinions while on the Massachusetts Appeals Court, she was also, before her appointment to the bench, an amazing advocate, dedicated and energetic in her efforts to right wrongs. Gabrielle Wolohojian would be a superb Associate Justice of the Supreme Judicial Court, and we endorse her nomination enthusiastically. In addition to reading all these letters over the past several weeks, I have had the privilege of getting to know Justice Wolohojian myself. And I can confirm that beyond being a brilliant judge, an accomplished violinist, and a proud member of our state's Armenian community, Justice Wolohojian is a deeply thoughtful individual, a quick wit, pretty knockout baker and chef, and she'll make an excellent addition to our state's highest court. And now it is my honor to recognize Governor Healy, who has come to formally introduce the nominee. Good morning, Governor.
Good morning, Lieutenant Governor, and good morning, members of the Governor's Council. Today marks the hearing on the administration's 17th nomination to our courts and the second for our highest court, the SJC. With the assistance of our two judicial nominating commissions and the Joint Bar Committee, we have worked hard to nominate for all of our courts the very best candidates, people with experience, integrity, diverse backgrounds, and dedication to the rule of law. People who are determined and ready to contribute to and further the work of the courts immediately. We have been proud to nominate talented individuals from across the state who come from many different backgrounds and who bring with them wisdom gained from different experiences. I know that the Governor's Council has worked hard to consider, study, and decide on these nominations. As governor and as a lawyer, former, but one who did practice in courts in the state for 25 years, know that I take seriously the responsibility of selecting for the council's advice and consent the absolute highest caliber of judicial nominees. I thank the council for its work in ensuring that our judiciary is and remains strong. I am honored to recommend to you today Appeals Court Associate Justice Gabrielle Wolohojian as this administration's second nominee to serve on the Supreme Judicial Court. As a judge on the Appeals Court for the past 16 years, Judge Wolohojian has earned a place, rightfully, as one of the state's most respected judges and most respected stewards of our courts. Her work is widely known and widely praised. This is clear from the overwhelming support that she has received from the legal community and beyond, as the Lieutenant Governor spoke of in her remarks. Our Supreme Judicial Court Nominating Commission unanimously recommended that Judge Wolohojian be elevated to the SJC. The Joint Bar Committee unanimously granted her their highest rating. And numerous judges and lawyers who practice in courts throughout this Commonwealth have expressed their enthusiastic support for her nomination. It's rare for so many lawyers and judges to agree. And yet, in this instance, it's not surprising. As all of these lawyers, judges, court personnel, and others know, and as I know, there is no candidate more qualified or better prepared for this critically important role at this time. Judge Wolohojian has distinguished herself as a fair-minded jurist, an open-minded listener and questioner, and a mentor to so many attorneys, judges, and law clerks. As seen in the decisions she's written, Judge Wolohojian is an expert on civil and criminal law, and a judge who, importantly, prizes consensus. In her work, we see a commitment to supporting the work of other judges, to improving public understanding of our courts, and to strengthening the administration of justice. Time and again, Judge Wolohojian has proven herself to be a person of wisdom and integrity, deeply committed to both the rule of law and the strengthening of our community. Since joining the appeals court, Judge Wolohojian has given generously of her time, serving on and leading a number of committees, including those on mentoring and training of new judges, judicial education and policies, procedures, and rules. As we see in the outpouring of support from her colleagues on the bench and reflected in this auditorium today, Judge Wolohojian has earned nearly universal respect for her talents and accomplishments and for the contributions she has already made to our court system. To the litigants who come before her and her colleagues at the court, Judge Wolohojian has displayed kindness, patience, empathy, humility, and an abiding sense of justice. As we've heard today, and as I have consistently heard from advisors I trust, and as I know from experience, Judge Wolohojian is a remarkable jurist, uniquely talented, thoroughly prepared, generously willing to serve, and deeply committed to our judicial institutions. And I know that personally. As I have said in the past, a personal relationship and my personal relationship with Judge Wolohojian should not deprive the people of Massachusetts of an outstanding SJC justice. For this position as Associate Justice of the Supreme Judicial Court, I can think of no qualification more essential than being ready on day one. Ready on day one for the demands of the job, ready on day one to understand the critically important role of the court, and ready on day one to decide the most difficult, most complex, and most important cases facing our state. There's no person more ready to do that than Judge Wolohojian. She has the experience, the qualifications, the judgment, and the temperament to fill this role and to excel at it. I thank you for the opportunity to appear before you today, and I thank the council for its consideration of our nomination.
Thank you, Governor. At this time, I'd ask the not of the governor, no, but we do have witnesses that are coming. Thank you, Governor. I'll ask the nominee, Justice Wolohojian, to join us at the witness table. Justice Wolohojian, I understand that you have your mother and some other family members and friends, certainly a lot of friends and colleagues who are here. If you'd like to take a moment to introduce anyone with you that you would like, please do so. Okay. That button in the, yeah, you got it.
I see you can turn me off.
I can't. Somebody in this room can. Mr. Oz behind the curtain can turn you on or off, I guess.
Well, thank you for giving me the opportunity to introduce the people who are here. I greatly appreciate it. Thank you, Lieutenant Governor. Thank you, my home counselor, Devaney. And thank you to the remaining governor's counselors. I thank Governor Healy for this nomination, and I appreciate this opportunity to introduce to you the people who are attending this hearing. I am honored by the presence and support of people who represent the many different facets of my life. I'd like to begin with acknowledging the presence of many members of the Massachusetts judiciary, which I honestly believe is unrivaled in this country. Present are Supreme Judicial Court Justices Frank Gaziano, Scott Kafker, and Dalila Wentland. Retired Supreme Judicial Court Justice Nan Duffley. On my beloved appeals court, present are Chief Justice Green, Senior Associate Justice Vuno, Justice William Meade, Justice Peter Rubin, Justice Amy Blake, Justice Gregory Massing, Justice Eric Nyman, Justice Vicki Henry, Justice Kenneth Desmond, Justice Peter Sachs, Justice Catherine Hand, Justice Suk-Young Shin, Justice Joseph Ditkoff, Justice Marguerite Grant, Justice Rachel Hirschfang, Justice Robert Brennan, Justice Christopher Hodgins, Justice Paul Smith, and retired Justices Peter Agnes, the legendary and great Fred Brown, Justice Cindy Cohen, retired Justice Fran Fecto, Justices Andrew Granger, Mel Greenberg, Jeffrey Kinder, Diana Maldonado, David Mills, and retired Justice Mary Sullivan. This morning, I paused as I was struck by what it means to have the support of my current colleagues. And I realized that their trust and support, that if I were elevated, they would be happy to have me review their work, struck me as the greatest trust and endorsement that I could receive. I will be forever grateful for that. I'd also like to acknowledge the presence of members of the federal judiciary, including Judge Ria Zobel of the United States District Court for the District of Massachusetts. I'd like to recognize members of the bar, including my former partners and colleagues from the law firm of Wilmer Hale, formerly known as Hale & Dorr. I'd also like to thank and acknowledge my former boss, Bob Fisk, under whose direction I worked when he served as the first independent counsel of the Whitewater investigation. I'd like to thank and acknowledge Anthony Barsamian, co-chair of the Armenian Assembly of America. I'd like to thank and acknowledge Attorney Sonia Nersessian, immediate past chair of the Armenian Bar Association. I'd like to acknowledge the members of the staff of the appeals court, including members of the clerk's office, court officers, staff attorneys, secretaries, and administrative personnel. Also present are my law clerks, past and present, my friends, musicians, especially those with whom I play in the Boston Civic Symphony. And if anyone is looking for anything to do on March 3rd, we're playing at Jordan Hall at 3 p.m. I don't know that this crowd is actually going to produce any tickets. Also present are members of my family, including my niece, Luna Dellens, and her father, Darius Dellens, and my brother and other families who unfortunately cannot be here physically today, but are watching on the live stream. And finally, in a category all her own, is my mother, Florence Wolohojian, who may hold the record for number of times she's come to watch appeals court arguments. Luckily, she seems to think I'm doing an okay job, although she does think I need to sit up straighter. Thank you.
Thank you very much, Justice Wolohojian. I know that you submitted a witness list of 2 people who will be speaking on your behalf to the Governor's Council. That's Justice Arian Vuno and Jennifer Martin. I'm also informed that there are additional speakers who have notified the council that they wish to speak. For those who are not on the list and who wish to speak, we will provide an opportunity for you to be heard on this nomination. There are index cards. There are index cards on the table outside the door to the auditorium. If you're not already on the witness list but wish to speak at this hearing, please print your name and address on an index card, indicate whether you'll be speaking in favor of the nomination or in opposition to the nomination, and then your index cards will be passed to me by this gentleman right here. As you can see, there are many people here today who wish to be heard, so we're going to ask that all witnesses keep their remarks to 3 to 5 minutes so that everyone has an opportunity to be heard. We will ask that you wrap up your comments at that time. And if you go over 5 minutes, I'm going to respectfully ask you to conclude your remarks. In addition, there are 2 legal pads on the table for those who do not wish to speak, but who want to be recorded, either in support or opposition. One legal pad is for supporters. The other legal pad is for opponents. You're invited to sign your name and address as indicated on the legal pads at any time during the day. And now let's get to it. So I'd ask the nominee to identify the order of the witnesses who will be coming forward.
Lieutenant Governor, members of the Governor's Council, I have 2 witnesses to speak on my behalf today. The first is Senior Associate Justice Arian Vuno of the Massachusetts Appeals Court. Justice Vuno and I have served together on the appeals court for my entire tenure on that court. The second is Ms. Jennifer Martin, who has been my judicial secretary since 2010 and has seen me at my best and worst, and even worst. I have had 3 legal secretaries during my career. All of them have been amazing women. And I am honored that in addition to Jennifer, my other judicial secretary, Eileen Smith, is here too.
So we'll call Justice Vuno first. Perfect.
Yes, thank you.
Yeah, okay. Good morning.
Good morning.
We're going to make sure we turn your microphone on.
I got it now.
Perfect.
Okay. Good morning, Lieutenant Governor, members of the Governor's Executive Council, Justice Wolohojian, family and friends, and our colleagues. It is an honor to be here. I'm going to have to speak fairly quickly to stick within my allotted time, so I will do the best I can. My name is Arian Vuno, and I am the Senior Associate Justice of the Massachusetts Appeals Court. I met Justice Wolohojian when she was appointed to the appeals court 16 years ago. I did not know her previously, but her reputation preceded her. As you know, she has had a varied and illustrious academic and legal career before coming to the appeals court. She not only lived up to her reputation, but she very quickly exceeded it. She has been described as a thoughtful and caring judge. This is true. She is also a thoughtful and caring person, one who treats everyone equally and with respect, both inside and outside of the courtroom. I describe her as a leader. She is a true North Star. During my tenure on the appeals court, almost 18 years now, I have had the opportunity to work alongside many exceptional judges, 6 of whom were nominated to the Supreme Judicial Court and confirmed by many of you. They have made enormous contributions to our jurisprudence and consequently to the lives of the citizens of the Commonwealth. In my view, and clearly I'm not alone, Justice Wolohojian should be with this group of our former colleagues who have been elevated to the SJC. She has 16 years of judicial appellate experience, during which she has demonstrated that she has the talent, the intellect, and the stamina to be an outstanding justice of the SJC. Now, in the time allotted to me, which is far too short to cover all of Justice Wolohojian's accomplishments, I want to touch upon her commitment to the rule of law, to the actual work of our court, that is the rendering of well-reasoned and sound decisions that resolve conflicts, and to the appeals court as an institution. But first, while it may seem apparent to everyone here that at this moment, the nominee is the most important person in the room, there is one person who, let's just say, has some seniority. She has already been introduced to you, but I would like to acknowledge her again. That's Justice Wolohojian's mother, Florence Wolohojian. Mrs. Wolohojian is Florence Wolohojian is a remarkable person. She is the daughter of Armenian refugees. Her parents were forced to flee Istanbul in the early 20th century. Many relatives were not so fortunate. Some died in jail or died trying to escape. Florence's parents helped many families emigrate to the United States. This history has not been lost on her or her daughter, or the community where Mrs. Wolohojian now lives. I understand there's a large contingent of people of Armenian descent who are here today to support this nomination. They are proud today, but I know Florence Wolohojian is the most proud of all, as she should be. And I have no doubt that Gabrielle's father, who was with us in spirit, shares in that pride. I'm going to pause and use some of my time, about 30 seconds, just for a moment, to look around this room. In addition to the Armenian community, members of the Boston Civic Symphony are here. As you know, Justice Wolohojian is a highly regarded amateur violinist, and she's a valued member of that symphony. We are joined today by members of Justice Wolohojian's book clubs, theater groups, neighbors, former colleagues from the law firm where she was a partner, former clients, opposing counsel, and of course, so many members of the current and former justices of the appeals court, Chief Justice Green, and many members of the appeals court staff. And those who can't be here today are watching on the live stream at the courthouse. In addition, there are former and current SJC justices here who have already been introduced by Justice Wolohojian. The presence of all these people to support this nomination speaks volumes about Justice Wolohojian's character. And now let me turn specifically to her qualifications. I mentioned her intellect. It is truly unparalleled. Lawyers love to appear before her because she zeroes in on the key issues and often articulates them better than they have. Her colleagues love to sit with her because we know her preparation leaves no stone unturned, and that our discussions of the cases after oral argument will be thorough, productive, collegial, and sometimes even a bit entertaining. She does have a good sense of humor, an important attribute when we are so often dealing with such hardship in the cases that are before us. She has compassion. She approaches every case without any bias, prejudice, or preconceived notion of how the case should turn out. She takes no shortcuts, none. She has an extraordinary work ethic and is known for burning the midnight oil in the courthouse. She has enormous capacity to listen and then contribute to a discussion in a persuasive but always cordial manner. In deciding cases, she's faithful to the record, and she writes decisions that can be understood not just by the lawyers, but by the parties and the public. Of course, the best evidence of that is a matter of public record. She has participated in adjudicating approximately 2,700 appeals, written 900 decisions, and of those, over 125 are published decisions, every one of which is impressive for its clarity and analytical integrity. I note that these decisions address civil and criminal appeals arising from all 7 trial court departments and administrative agencies from across the Commonwealth.
We've got about a minute, Justice Funo.
Okay. Well, I'm not going to talk about her fantastic and dedication to the committee work, to her mentoring program at the appeals court. I dare say that the people that she has mentored over the last 14 years at our court will miss her the most. But I do want to turn to one particular comment and talk to you a little bit about what Justice Wolohojian brings to the court, given her loyalty to every single person on the court. You will hear more about this from the next witness. I just want to tell you that if someone on our court has a problem and she hears about it, she is going to solve it. If she has to hop in her car or hop on her bike and go to that person in need, she is the one that you can count on. I said she was a leader, and that's true. In closing, I note that some of you were here 16 years ago when Attorney Wolohojian appeared before you after she was nominated by Governor Deval Patrick. Today, I urge you to vote in her favor again, because if confirmed, I am confident she will bring to the SJC the same qualities you recognized then, and that we as a court have seen over the last 16 years. The justices of the SJC have an awesome responsibility. And I, together with all those who are here to support Justice Wolohojian, would like to see that responsibility in the hands of a jurist like her. She will bring her appellate training and life experience to the position. She will bring her extensive knowledge of the law, an open mind, and a credible level of energy, and she will dedicate herself to reaching the correct conclusion, guided only by fairness and justice. I applaud the governor and the lieutenant governor for nominating such a worthy candidate. And I urge you, despite what will be a huge loss to the appeals court, to confirm her nomination.
Thank you, Justice Funo. Thank you for your testimony. I'll now give counselors an opportunity to ask questions of the witness. Do any counselors have questions? Counselor Kennedy.
Good morning, Judge.
Good morning.
It's good to see you. Your comments really mean a lot. I know
could have
that,
spoken a little bit longer, but I had to stay within my time limit.
I know that you were approached about applying for the SJC in the past, and you turned it down. I know that for a fact, and I think it was on more than one occasion. And I want to ask you, was there something about the job you haven't told the nominee that maybe she should reconsider?
It's a very hard job.
Thank you for your comments.
Thank you. Any other members of the council have questions for this witness?
I have a question.
Seeing none? Thank you,
I have a
Justice
question.
Funo.
Thank you. Thank you very much.
Oh, I'm so sorry. Is there a question?
Yes,
Oh,
I have a
Chris,
question.
I'm so sorry, Chris.
Oh,
You almost
Counselor
forgot.
Ionella.
Yeah, just
One
one
second. I want to
question.
make sure we can hear you on the speakers here.
Can you hear
Should
me?
be good. We can hear you. Thank you, Counselor
Okay,
Ionella.
thank you. Thank you, Justice, for your service over the past 18 years to the Commonwealth. I have one question. Can you tell us, where you've worked with her for 18 years, about qualities that I think are so important: judicial temperament and someone's character?
yes, I can say that Justice Wolohojian really exemplifies the epitome of what you want in somebody who can listen, who can be persuasive with, as I indicated before, in a cordial manner, but more importantly, to be persuasive in a way that makes the other people in the room feel as if they're being listened and their points are being taken into consideration. And I think that's very important, especially when you're thinking about sitting on a 7-member panel. I talked a little bit about her compassion, and you're going to hear some more about that, Counselor. When I call Justice Wolohojian a North Star, is because, as I said before, she's someone you can count on. And that is a character trait that is quite unusual, very rare. Reserve that particular compliment for only one other person in my family. So that's all I can say there.
Thank you.
I think that concludes questions. And thank you, Counselor Jacobs, for flagging me down with Counselor Ionella's question. At this point, I will ask our next witness to come forward, Counselor Miss Martin, Jennifer Martin. Thank you, Justice Funo.
Thank you. Good morning, everyone. This is not intimidating at all.
You are doing fine, Miss Martin.
Thank you for allowing me to speak on behalf of the nomination of Justice Gabrielle Wolohojian. My name is Jennifer Martin. I've worked at the appeals court for 25 years, spending the last 14 working alongside Justice Wolohojian as her judicial secretary. And during our time together, I've learned from her, I've grown with her, and I have developed professionally with her guidance and respect. I come before you today to share my experience with you as you consider this very important decision. I would like to elaborate on the kind, generous, and thoughtful person I have the privilege of knowing. She gives so much love and devotion to her family and her relationships with them. She's an amazing daughter to her mother, Florence, always making a point to include her mother in events that might interest her. She is a supportive, loving sister to her brother, Stefan. She is a fun-loving aunt to many nieces and nephews, and she's a doting niece to her elderly aunts and uncles, keeping her family connected by hosting holidays and arranging for the elder members of the family to be together and share memorable experiences. Justice Wolohojian has also been involved in mentoring our youth. She regularly judges mock trials and moot courts, and she gives her time to elementary school children touring the John Adams Courthouse. She has spent time with them, explaining the judicial system, with the children in the Great Hall, talking and answering questions they have. And more than once I've seen them in a circle with their legs all crisscrossed, and they're all just talking. It's cute as a button. She enjoys the same type of mentoring to high school and law students, always making time for questions and answers when the appeals court hears oral arguments away from the courthouse. We all know what a great scholar Justice Wolohojian is, but some of us are lucky enough to experience how creative and resourceful she is. For many years, she was the chair of the appeals court's social committee, where she shared amazing creative ideas and allowed the members of the committee to participate in the creative process by getting us excited and to build up our own confidence and our own creativity. We've put on some amazingly wonderful events at the appeals court over the years, and it was because of her ability to unite everyone. Her love of cooking is well known. She's always willing to talk about the amazing meals she has crafted, and her baking is legendary at the appeals court. When Justice Wolohojian brings in baked goods, the hallways become filled with the sounds of increasingly desperate footsteps, hoping to reach the kitchenette before the last piece is gone. Every year, she shares her love of baking by preparing and distributing her much look forward to granola. She makes a point of giving everyone their own personally addressed gift, packaged individually, tied with a ribbon, and a handwritten label with your name. Not only does Justice Wolohojian know the name of every employee at the appeals court, from the parking garage, our building security, our court facilities, she knows and inquires about their family members as well. She takes a genuine interest in the people around her. She's the first to share heartfelt congratulations, words of encouragement, and when the time unfortunately comes, condolences. When new employees arrive at the appeals court, Justice Wolohojian takes the time to introduce herself, and she finds the time to get to know them. Justice Wolohojian's support shows through her actions as well as her thoughtful words. When face masks were impossible to come by at the start of the pandemic, Justice Wolohojian took out her sewing machine and made face masks. In fact, my first face mask was a Justice Wolohojian original. Around the same time, she went to the courthouse, retrieved my ergonomic keyboard, file folders, and any office supplies I needed to work remotely, and she delivered them to me so that I didn't have to put myself at risk. This is the person I know, a kind, family-oriented, creative, generous mentor who truly cares about the people that come into her life. Justice Wolohojian gave me strength and encouragement when I was diagnosed with a serious illness. She showed me kindness, patience, and empathy when I experienced great loss within my own family. She's been a wonderful friend and an amazing role model for me. I am so happy she has this incredible opportunity, but from a personal standpoint, I'm going to miss seeing and talking to my friend every day. I hope my words have demonstrated her extraordinariness, and I hope you all are lucky enough to have a person like Justice Wolohojian in your life as well. Thank you again for your time.
Thank you, Ms. Martin, for your remarks. Are there any questions from members of the council? Counselor Devaney.
Thank you. Your Oh, I'm sorry. Your testimony is very heartfelt. Tell me about her temperament. Tell me about under stress. What have you seen?
She's patient, she's kind, she listens to everything and everybody. She gives you your time, your space. She respects you, your opinion. She's non-judgmental, well, in a good way. Yeah, but, yeah. She's been very patient with me. She helped me grow up, so she's very patient, she's very kind. She is, as Justice Vuno said, she's the one, she will solve the problem. You tell her what the problem is, she will, it'll be solved.
Thank you. Really appreciate your testimony.
Thank you for having me. I appreciate it.
Any of the members of the council have questions? Thank you so much, Ms. Martin. Appreciate you being here. Okay, I think what we'll do now is we'll hear from witnesses who indicated before the hearing that they'd like to come speak in opposition. And I know we've got a few folks on the list. In opposition, I'm going to start with Sarah McKee. Well, we're going to start with opposition, then we're going to move to support. So, yeah, so Ms. McKee, I'm not sure if you're here, if you're here virtually.
Yes.
Okay. Ms. McKee, go ahead, please.
I can't get this to work.
It's working. We
Oh.
can hear you, Ms. McKee.
Okay, excellent. Thank you very much for this opportunity. I am delivering the testimony of Hon M. Cofield, President of the Social Justice Foundation. And it's dated today, members of the Massachusetts Governor's Council. Thank you so much for taking my testimony in absentia today. The Social Justice Foundation is actively engaged in fighting for the enforcement of the 14th Amendment of the U.S. Constitution. This includes well-recognized civil rights issues. Certainly, the right to enjoy one's property, one's home, is among these rights. Fundamental to our court system is that a court has jurisdiction only when the parties in front of it are real parties in interest. The court must always ensure that it has jurisdiction before it moves forward in any way on any case. That is the first obligation of the court. The honorable nominee, Gabrielle Wolohojian, has rendered many decisions where one of the parties in front of her literally could not prove that it had a legal existence. Yet, she has never questioned the issue or addressed it. As somebody who has been personally fighting these issues due to indisputably predatory lending practices of AmeriQuest Mortgage Company, I am experienced in being before Massachusetts courts against a so-called securitized trust that had no executed founding document, but that nevertheless claimed ownership of my mortgage and note. These so-called securitized trusts were in front of the Supreme Judicial Court in the most famous case of this entire historically long and historically highest rate of foreclosure crisis since literally the founding of the United States. The U.S. Bank as trustee via Banya's decision, combined with the LaRosse case, addressed two purported securitized trusts. Neither could produce for the SJC a legally executed founding document, and the court therefore found them unable to have acquired a mortgage loan. I'll mention that the late Chief Justice Gantz, when he was a Superior Court judge, further settled the law that engaging in predatory, racist mortgages, such mortgages do not even legally exist pursuant to Massachusetts law. Massachusetts case law is absolutely clear. If a party is a non-human entity claiming to have legal existence and therefore allowed to enter the Massachusetts courts, it must have an executed founding document. Yet, the honorable nominee was on the bench when the Larosse case was back up before the appeals court. The lender still could not produce a fully executed founding document. Yet, the honorable nominee did not address this basic jurisdictional issue. If she is to be a Supreme Judicial Court, it seems, at a minimum, that this council should insist that she ascertain in every case whether the court even has jurisdiction. Similarly, when she has mortgage lenders before her that have been adjudicated to have been engaged in predatory and discriminatory mortgage lending, at a minimum, she must commit to enforcing Article 10 of the Massachusetts Constitution. She must also commit to enforcing Massachusetts Constitution, Article 1 of the Bill of Rights, which was amended to ensure that the right to hold property is not to be, quote, denied or abridged because of race, color, sex, creed, or national origin. Her judicial history reflects differently. Sincerely, Juan M. Cofield. I thank you.
Thank you, Ms. McKee. Are there any questions of this witness from members of the council? Seeing none, I will move on to our next witness in opposition, which is Janet Pidge. Janet, are you here or are you virtual? Perfect. If you could just come forward. Good morning.
Good morning to the committee. I thank you so much for allowing me to testify and to be on record. I have been abused for over 23 years by over 30 judges, and many, many people are involved in my case, including Maura Healy. I've tried to meet with Maura Healy since 2007, and we were denied that right to even meet with her in the Civil Rights Division, the Attorney General's office. When it came time to meet at the Attorney General's office, we had an advocate accompany us to that office because my sister Beverly and I, very quiet people, no matter who we tried to meet, they'd call security and kick us out of the building. And that continues to this day. So we tried to meet with Maura. They had us wait about an hour and a half. She refused to see us, so we met with State Trooper Johnson. He took a full report, believed we were being criminally targeted by the police, by many, many people, but we didn't know why all these judges were, abusing us. And for years and years, they kept this secret from us while we were being abused. My mother, my sister Beverly, and myself, and Marilyn Devaney is involved in my case, criminally. Since all of this happened, in 2018, they murdered my sister. I was power of attorney to my sister, pleaded with Maura to take a recorded statement from us. We contacted the FBI in Florida, David Rain. He said, you have that legal right. She wouldn't take a recorded statement from us. Middlesex District Attorney Mary Ann Ryan wouldn't take a recorded statement from us. We continued to make emergency phone calls. They put the murder hit on my sister October 4th, 2016. The Newton police would not meet with us, would not take a recorded statement. We tried to meet with higher judges. We drove across the Commonwealth. Nobody would ever see us. No prosecutor, because Mary Ann Ryan, she's criminally involved in my case. So I've been trying to convene a grand jury to put Maura Healy and Mary Ann Ryan on trial because since my sister was murdered in 2018, I was told the city of Newton was no longer safe for me to live. I thought I'd stay living there until I died. So I moved to Belmont thinking, I'd be safe there, not knowing that Mary Ann Ryan is a resident there and Senator William Brownsberger. So I moved to 7 Chester Road. I was paying $2,500 plus utilities. I'm an extreme neat and quiet, never home. And I told, I paid realtors and I told the landlord, I'm a private person. I don't want anybody in my unit, when I do come home. He was in my unit about 15 times, had to call the police, the health department, no heat, no hot water. And this has gone on for years. And it goes way back to Newton. So to this day, I've never met the internal affairs investigator, Eric Rosenbaum in Newton. Nobody will meet with me. I've been trying to meet with Karen Spilker. I've been trying to meet with Bradley Jones. I mean, many, many people in the State House, including Marilyn Devaney, which I went to the Governor's Council again. I had spoken with attorney Mike Walsh from Linfield, and he looked up my case. He said, you're being criminally targeted. You have a right to counsel. I've paid thousands on lawyers. Some have had their law license suspended. I have done intakes with every legal agency across the Commonwealth, and they all said you have a right to counsel, but I'm being blacklisted. So to make a long story short, we were abused all these years, and we had no idea what was going on. It turned out we were also threatened by the FBI, and Senator Elizabeth Warren was supposed to investigate them, but then she found out Martha Coakley was involved in our case. So we were totally shunned by everybody. Whoever we were going to meet with at Senator Warren's office or, the Newton police, they would vacate that office. So right now, I have been illegally evicted from the Bradford in Belmont. They refused to take my rent check. I have since spent about $80,000 on hotels. And I went to Mayor Michelle Wu to try to get an emergency hotel voucher because I ran out of money. She threatened me. I had spoken with Boston officer Dan Harlow. He said, I'll call the Boston FBI for you since you were previously threatened by them. To this day, they will not meet with me. I have placed emergency phone calls. They'll transfer me to Virginia. They'll disconnect my phone call. And it just goes on and on and on like that. So I've been trying to meet with an emergency judge. I've been assaulted at the Easton Housing Court. I had a case with Judge Michael Malamet, and I knew immediately he was criminally targeting me. And I found out there was extreme conflicts of interest with him, and I asked him to, step down from the case. I warranted early summary judgment, like $30,000, $40,000. He refused to, again, further muzzled my voice, blocked a jury trial.
We're at time, Ms. Pidge. I'm going to need you to wrap it up, okay?
Yeah. So, I'm still trying to obtain counsel and to see an emergency judge at this point because I've been assaulted by people in Boston. Kevin Hayden will not meet with me. Colonel John Mon will not meet with me. I met 2 state police officers here a couple of weeks ago. He assured me he'd get an emergency meeting with me. That hasn't happened.
Thank you, Ms. Pidge. I need you to conclude your remarks. Are there any questions from members of the council for Ms. Pidge? Councilor Devaney.
Thank you. First of all, I never was involved in any of your cases. Goes back maybe even 10 years because I'm here every day in the office, and you came in to the council office and I talked with you, and I really pursued everything. I really gave it a lot of time. It was the most confusing involvement I ever had in my life. And I really couldn't help you. It was just, it seemed like everyone was wronging you. And I talked to people, and really, I'm very sorry, but I had nothing to do with any of your cases, as that you've said.
Yeah.
You came and you talked with me, I listened, I followed up, and it was just beyond my control to even address all of those people or whatever. And I honestly don't know how it applies to this nominee today.
It
So-
applies to Maura Healy and whoever she nominates.
Well-
I disagree with this.
Thank you. Any
Talk
questions,
all these
Councilor Devaney?
condiments and all these
Councilor, any
judges.
questions? If there are
They're
none,
not
then I
fine.
pass along.
You're not telling the truth.
Ms.
You
Pidge,
and I met.
please allow Councilor Devaney
All
to
right, my
ask a
question
question,
is,
and then we'll move
what
forward.
do you want to accomplish here today? You are opposed to this nominee.
Mhm.
Okay,
Strongly.
and and throwing out all of the other things that you have going on for years, all right, all those cases.
I've been abused by over
What-
30 judges.
What is the particular opposition you have for this person to take this position?
I would like to see an emergency judge, which you were going to make that happen. You and I had an hour conversation when I lived in Newton. My sister Beverly and I met with you, and then you told Advocate Tom Sheff you never met with us, which is a total lie. You had complaints about judges and crooked cops and this and that. I mean, you're not being truthful whatsoever. And then I had a reporter, Eaton from Framingham. He's now in Washington. You contacted him to squash our story. He was going to report on my story. I need media coverage. Like I just also contacted, I'm a Brockton lawyer, attorney Michael Maloney. He says, I'm going to get you media coverage. That's the
Excuse me,
Thank you for your response.
We're going far afield and.
Lieutenant Governor, point of order, this is totally out of
And I
place.
really.
Councilor
you know,
Devaney, are there any other questions?
Madam
No,
Chair,
that's
Let's
the question I
conclude.
had.
Any other questions
And
for
I-
Ms. Pidge?
I really wish
Seeing
that
none,
my name
we'll-
didn't keep coming up on your cases because I had.
Thank you,
nothing-
Counselor.
I'm still being
Thank you.
accused. Yeah.
Thank you.
Thank you, Ms. Pidge. We're going to move on to the next person who wants to
Thank
speak.
you.
Thank you. Next up on our list is Grace Ross, and I believe I saw Grace here virtually. So if we can put Grace on speaker, we'll move forward. And Grace, you'll have 5 minutes once you get started.
Can you hear me?
We can, Grace. Good morning.
All right. Thank you so much for hearing us. And I hope that this is understood in the context that, the law is about argument and debate, and it's not a personal matter. The concerns that I would raise about the honorable nominee Wolohojian have to do with, we've actually in this situation had extensive experience with her adjudications because she's been sitting on the appeals bench for so long. And I will send the council members a longer explanation with the proper citations, et cetera. But I think the question is, a jurist who is going to become an SJC judge has a special burden in our system. They are going to be setting legal precedent. They are going to be responsible for constitutional interpretation, especially and inclusive of critical elements such as equal protection, constitutional interpretation, and due process, guaranteeing due process for all of us, even for instance, when we're indigent, and separation of powers, which is critically important because our three branches of government provide under our Constitution for interpretation by judges, not the rewriting of statutory language or regulatory language. They are to interpret, not shift it to mean something slightly different. And it's critically important that our top jurists look at the history of a statute for interpretation of the words if there's a question about the wording, but not rewrite it, not accept words. So for instance, we have a unique snapshot of this nominee because the Ibanez decision that's been mentioned already came down in 2011. It was combined with the LaRosse case and stated very clearly our real property requirements, including things that render transactions void, which is a key concept in real property. The Eaton decision, the second most famous decision related to foreclosures in 2012. And the honorable nominee was justice on a decision then in 2013, HSBC Bank v. Norris, and held very critically that the homeowner had a right to discovery in terms of the viewing the original note and the production of the founding document for a securitized trust mentioned previously. They're called pooling and servicing agreements. Amazingly, years later, the LaRosse case, one of the two combined Ibanez cases, ends up in front of the Honorable Wolohojian, and she's part of the decision-making in that case. Having held early on that the pooling and servicing agreement is evidence a homeowner has a right to, and the original note is something the homeowner has a right to, no doubt, because the debt still has to be negotiable when they go to foreclose on your home. In LaRosse, she holds that the homeowner has no standing in relationship to the note transfers and has no standing in relationship to challenging whether the securitized trust exists or not. So she reversed, and it's not clear why she would have reversed a very clear, simple, straightforward holding that lay exactly in line with the specific wording of the Ibanez decision that held that a pooling and servicing agreement is controlling, that it is under the choice of laws of the governing law, in these cases of New York or Delaware, and that the necessity for a non-human legal entity to exist included an executed founding document. But when she gets the LaRosse case, when it comes back up on appeal, she holds the opposite, but she's holding the opposite as to her own decision in 2013. We are looking at the largest foreclosure crisis in history, and understanding mortgages and notes is going to be critical to then providing equal justice to everyone who has experienced predatory and, in most cases, discriminatory lending. Our Massachusetts Equal Rights Act, which, by the way, has not yet been adjudicated as to real property by the SJC, so this is going to be a hot matter in front of her.
Ms. Ross, I'm going to have to ask you to conclude your remarks. We're at time.
Okay, I have two quick things. We need the Equal Rights Act enforced as to equal property rights, and the mortgage and note that she was looking at in LaRosse, if she had actually looked at the instrument, the maturity date was on the front page of the mortgage, and the note says it is accelerated through the acceleration of the mortgage, and she held the opposite without apparently having looked at the instruments that are the basis of the decision. So
Thank you,
we
Ms.
have
Ross.
great hopes that these things and this form of adjudication is something that she is prepared to pick up, but the track record so far is not as bright and shiny as we would like.
Thank you. Are there any questions of the witness from members of the Governor's Council? Seeing none, I will move on to our next person.
Thank you.
Which is, thank you, Jean Mitchell. I'm not sure if Jean is
Hi.
here.
Jeannie had a medical appointment and has been stuck in traffic, and if there is any way her testimony could be taken later, she plans to sign in immediately, and we will call staff and let them know when she's in.
You can do so. We'll see what point we're at in the program.
Obviously, much appreciated. Thank you, Lieutenant
Thank
Governor.
you. And Casey Lenardin. If Casey is either here or virtual, he or she could let us know. Not virtual and not in person. Okay. If there are any additional witnesses in opposition who have signed index cards who have not been called, then I'm going to move forward and close that portion. If there are no other witnesses in oppositions for the nominee, we're going to now close testimony against the nomination. And we will move forward with individuals who are witnesses who are here in favor of the nomination who have signed up to speak during the hearing. And we've got a few on the list here, starting with Joan Lurkey. If Joan is here, please come forward. Did I say your name correctly? Okay, I am so sorry. I'm reading somebody else's penmanship. Apologies.
All right. My name is Joan Lukey. Those of you who were members of the council 16 years ago will recall that I testified on behalf of Justice Wolohojian's nomination at that time. I have been before you on other occasions as well for Justice Marshall, for Justice Wendland, and for a few others. I very much appreciate the chance to speak briefly to you here. Justice Wolohojian was my mentee when she first began at Hale and Dorr. And that began as follows. The esteemed federal judge, Rhea Zobel, who has come here today to show her support, called me one day and said, "I'd like to ask a small favor. One of my most extraordinary law clerks is starting in a few weeks at your firm. Would you keep an eye out for her?" So I arranged for Gabrielle to be in the office next to me, the associate's office next to me. And I soon realized that it was the judge who had done a favor for me rather than myself doing a favor for her. In short order, it was clear that now Justice Wolohojian was among the most talented young lawyers I had ever met. And over the years, she obviously advanced and became my equal as my partner, and certainly exceeded being my equal in intellect and in other respects. I will tell you about just a couple of brief matters that I think go to the questions that were actually raised by a couple of the counselors today. One, I believe it was Justice Devaney raised the issue about how is her temperament, particularly in stressful situations. There is no more stressful situation in the law of a lawyer than a trial. And Justice Wolohojian and I, when she was an associate and then a partner, tried a number of cases together. If ever there is a time that a lawyer might be tempted to skirt over the line a little bit to make a point because she or he believes the end justifies the means, it would be in a trial that lasts 4, 5, 6 weeks. Having then Gabrielle, now Justice Wolohojian, by my side, I knew I had a constant balance on all conduct that helped me to remember that the end never justifies the means. She was extraordinary. I have never known a person of greater integrity, including in those times under stress when folks are perhaps more tempted to step a little too far. Not once did she do so, and she has made me a better lawyer and a better person. And then I am simply going to close with what to me says more about the person that she is than any other incident I can imagine. We were assigned together to represent a pharmaceutical company that was a client, a large client of our firm, Hale & Dorr. That pharmaceutical company was a very responsible company, had realized there was a problem with one of their drugs, and a lawsuit had been filed that tragically involved the death of a young boy as a result of a complication of that drug, which the pharmaceutical company had removed from the market by that time. We immediately went into mediation with the family, the parents, with the mother acting as the principal spokesperson for her son. And it was painful. It was not difficult in the sense that our client was being a problem. The company was being responsible. But we worked with an excellent mediator. We worked it through to the end. There were probably 10 or 12 of us in the room. It really didn't take that long. A settlement was reached. And when the last signature was placed on the agreement, Gabrielle, Justice Wolohojian, stood up and walked over to opposing counsel, shook his hand, but said, "May I address your client directly?" And he was someone who knew me well, because I'm considerably older. And I nodded to him that it would be okay. And he said yes. She went over to the mother, took the mother's hand, and said, "I cannot tell you how sorry I am, and all of us in this room on our side of the table are, for your loss." The mother stood up and they hugged each other. And I'm pretty sure there were tears running down both cheeks, and I sure know there were on mine. And what I thought that day was, I wish I could be the kind of person she is, that I would have thought of doing that, instead of simply thinking of doing what was fair and right, but was not entirely as empathetic as it should have been. That is the kind of person that you have the opportunity to put on the Supreme Judicial Court. What an extraordinary opportunity it is. I'm pushing up on dangerously close to 50 years in practice before the Massachusetts courts. I figure I've got maybe another 5 if I'm lucky, and I would really, really love it if the caliber of the court, which is already extraordinary, could be further enhanced by an unbelievably qualified candidate who stands before you now. You may someday find other candidates who might equal her intellect. You'll probably find some someday who equal her writing abilities. But I wonder if we'll ever have a chance to equal the empathy that this woman brings as a person to the bar and now to the bench. Thank you all for the opportunity to address you. We appreciate it.
Thank you, Attorney Lukey. Apologies for mispronouncing your name, and I
It's
could just,
usually lucky, and I like that.
but 1 minute, please. We want to make sure any Governor's Council members have questions. Counselor Devaney.
Thank you. That was outstanding. Thank you. I have just one question. What would you say is the most outstanding quality that this nominee brings to the position?
She's got a lot of them. From what I just said, you'll probably ascertain that I do think that her ability to be empathetic in every situation is the most outstanding quality. But I suspect were I one of her colleagues, which I will never be, that it would be her extraordinary intellect and willingness to assist them in reaching consensus. She's very good at that.
Your testimony means a lot. Thank you so much.
My pleasure.
Any other questions from members of the Governor's Council? Okay, seeing none, thank you so much. Patrick McCabe. Is Patrick here or virtual? Yep. Oh, of course, Patrick. That Patrick McCabe.
Thank you very much. My name is Patrick McCabe. I am that Patrick McCabe. So nice to see all the familiar faces here over the years. I'm only going to address one issue. That issue has to do with the custody decision when you have two married parents and they're both capable and fit parents. Our concern is that our laws changed 50 years ago from fault divorce to no fault divorce. During that time, there's been difficulty in the court in embracing shared parenting 50-50. I believe that this nominee can embrace that. She's been on the bench for the years. She's seen the changes. I do believe she can do that. And in fact, I believe every judge on the Supreme Judicial Court, even the ones that voted in the last decision, the Miller case, can embrace shared custody 50-50 parenting when you have two capable and fit parents. In 2020, in the Lepine case, along with Justice Green, the appeals court had a case where the parties had 50-50 custody. After the decision, it remained so. In that same year, along with Justice Henry, Michelin Grashla case, again, another 50-50 case. She has a long history, but the recent cases show that I believe we're going in the direction of treating parents fairly, equally, and more people are supporting shared custody, 50-50 parenting, which is what I support, and I hope this nominee will as well.
Thank you, Patrick. Members of the Governor's Council, Councilor Ferreira.
Thank you. You know that issue is near and dear to my heart as a divorced dad who had shared physical custody of my 3 young girls when they were 2, 6, and 8, and it worked out perfectly. And I can assure you that when the nominee took the time to come to Fall River the other day, we had this conversation about how important that is for me and for dads and for moms. And I can assure you that she gave all the right answers, that she's a firm believer that children need their moms and their dads, when it's appropriate. But she was very much in favor of that. Thank you.
Thank you, Councilor Ferreira. Any other questions? Councilor Devaney.
Thank you. I just want to mention that Patrick has come before us for years. I have met with the Fathers Coalition, and he has been a leader and a role model, and changes have been made because, as someone that looks from the outside, there has not been an equal right for fathers. And I have to say, Patrick, I thank you for all your involvement for all the decades, and thank you for coming today. I really appreciate it.
Thank you, Councilor Devaney.
I had one other comment, and that is on April 12th at Holy Name Church, the Sunrise Mass and Luminary is being performed by the Denham Choral Society.
Okay, very good to
Thank-
know. We're getting all the musical performances out. Before you leave, I believe Counselor Ianella, who is joining us virtually, has a question.
Not a question, just a statement. It's good to see you, Patrick. You've been coming to the council for a long, long time. As you know, more than anyone, I'm a strong advocate of 50-50 shared custody. So many nominees to the probate court come before us and they talk about shared custody or fair shared joint physical custody. Well, I always say, as you know, excuse me, shared could be 80-20. It's still shared. I, like you, are a strong advocate for children and believe the best thing for the children is a 50-50 shared custody. Thank you.
Thank you, Counselor Ianella. Appreciate that.
Thank you,
Thank you,
Patrick.
Patrick. Next up is Derek Grazza-Wells. If Derek is here, sure. Come forward and offer your testimony. I can still say good morning for 30 more seconds, Derek, so good morning.
Oh, take that 30 seconds. Hi, my name is Derek Grazza-Wells. I was Justice Wolohojian's law clerk during the last term at the appeals court. I really appreciate being able to speak on behalf of her nomination. Justice Wolohojian gave me my first opportunity out of law school when she selected me to be her law clerk. I consider it an incredible privilege to have learned from her, not only because she is a brilliant scholar with a keen understanding of the law, but also because she has been a kind, generous, and supportive mentor. Although she carries decades worth of experience, and I was just embarking on my legal career when I entered her chambers, Justice Wolohojian never made me feel small. Her critiques on my writing were incisive and purposeful. Her explanations were never personal or demeaning. They were indicative of how much care she put into every issue and every decision. As an example, I distinctly remember discussing a complex legal issue with Justice Wolohojian in preparation for oral arguments in a difficult case. I made a bad, self-deprecating joke about my little brain, and as you've seen today, she has a much better sense of humor than me. And she immediately told me that I shouldn't sell myself short, that I was smart, and that I needed to believe that. And I've carried that moment with me. It's only been a year or so, but I've carried it with me. It meant, and it still means a tremendous deal to me, to have someone that I respect so much be so supportive even on something so small. But that's the kind of mentor and person that Justice Wolohojian is. She wants her law clerks and interns to succeed and to be the best lawyers, and I think more importantly, the best people that they can be. I consider myself very lucky to have been her law clerk, to have learned from her, to continue having her as a mentor, and to be her friend. I'm so happy that she has this opportunity. I genuinely can't think of anyone more worthy or deserving. Thank you for allowing me to briefly sing the praises of Justice Wolohojian. If I had more time, I would definitely talk about her baking, but other people have covered that. Thank you for your time.
Thank you, Derek. Are there any members of the council who have questions for Derek? Okay, thank you so much for your testimony. Next up is Sonia Nenseshian. Is Sonia here or joining us virtually? Okay, here, perfect. Good afternoon. First time we've said that today.
Good afternoon. I'll be short because I know there are others that also want to speak, but you have the whole package here. You have someone who is a kind, thoughtful, empathetic person, the type of person you would like to sit on the bench. You have someone who's methodical and careful in her decisions, someone who's a brilliant intellect, and someone who is truly a very well-qualified candidate. And for me, here as a representative of the Armenian Bar Association, this is really an extraordinary person that we are so proud of. And we are very enthusiastic and without any reservation endorsing her nomination. So I cannot tell you how much this will mean for the Armenian community, but I can tell you that everyone who is either streaming this now or who is quietly and supportive of this nomination is really very, very delighted that she is the nominee. Thank you.
Thank you so much, Sonia. Let me see if any members of the council have any questions for you. Seeing none, thank you very much. Next up in order to speak in support is Anthony Basimian, and please help me if I'm pronouncing your name incorrectly. Apologies. Good afternoon, Anthony. How did I do? Not even close?
Well,
All right.
well, Anthony Barsamian, I am
right.
co-chair of the Armenian Assembly of America and the immediate past president of the Mass Council of Churches. We are extremely grateful to all of you, Governor's Council, the governor's staff, Lieutenant Governor, to have such an amazing person in Justice Wolohojian as a future justice to the Massachusetts court. I had the honor of working with the justice on a case in Massachusetts, which was when Armenian genocide was being challenged in the courts, in the federal courts. Justice Wolohojian, at that time a lawyer, presented an amicus brief. And that brief went before a 3-judge panel where Judge Souter was sitting on that panel. How important it was for us to have that decision, because not only did it defend the genocide, but it also defended the Holocaust, the African slave passage, the Irish famine, Rwandan and Cambodian genocides, and others. This, to me, is the work of a justice who has a true, deep understanding of human rights, and we are a grateful community, the Armenian American community. You know, today is an important day for Armenian Americans, not just because Justice Wolohojian's an amazing jurist, but because her character, her presence, and everything I've heard today makes us proud. Our families from Worcester and Watertown and throughout the Commonwealth, as you heard, stand proud today of genocide survivors and others around the globe who stand today and applaud you. And not left out are the next generation of young Armenian American women and other women who will see a justice who deserves this honor. Thank you so much.
Thank you, Anthony. Let me see if there's any questions from members of the council. Councilor Kennedy and then Councilor Devaney.
I just wanted to comment. For pride, I know the Armenian community is taking. Oh, I'm sorry. I just wanted to comment on pride that I know the Armenian community is taking in this nomination. I've received a number of calls and some letters. I spoke with my friend Sheriff Katusian, who was very, very pleased by this nomination as well. I know that my friend, who was very active in the Armenian community, who I knew my whole life, Speaker George Kavarian, would have been very proud today. He was a big advocate for the Armenian community, and I congratulate all of you on this nomination. I think it's a great source of pride for everybody involved. Thank you.
Thank you, Councilor. Councilor Devaney.
Thank you for coming. I think it's very important. People don't know the journey of how she has and you have been a leader and with the people who deny the genocide. And I want to thank you personally because I know what you have done. And I think it's admirable that this nominee has done that because the deny is really, it's outrageous. And we'll never forget what Hitler said in 1939. Who remembers the Armenians? I remember. So I thank you. And it's to be proud. And she's the first Armenian woman there. So we are really proud. So thank you for all you do.
Thank you.
Thank you, Councilor Devaney. Thank you, Anthony. I believe if there are no other witnesses in favor of the candidate, we can conclude that portion of the hearing. We do have Jean Mitchell, who was running late, who was in opposition. and I would ask the council's indulgence to allow her to offer her testimony. And so Jean is here virtually, I believe. So if I believe, Jean, if you're on, you can go ahead and proceed with your comments.
Okay, thank you so much. Members of the council, thank you for hearing my testimony today. My name is Jean Mitchell. I am a lifelong resident of the town of Clinton, Massachusetts. I bring over 10 years as a lay expert in question document examining. I've provided sworn documentary testimony for over 35 police departments throughout New England. When the foreclosures continued in the second decade of the century, I took on examining mortgage notes. A negotiable note that's evidence of the still existing debt is necessary for non-judicial foreclosure. Because our foreclosures are non-judicial, no judge reviews the documents before the foreclosing bank or securitized trust or government-sponsored enterprise can go through with the foreclosure auction. Thanks to Division of Banks, people are required to be sent a copy of the note and chain of evidence to prove ownership of the note, which is necessary to show that it's still negotiable in terms of legal transfers of the note. Of the first 80 notes I viewed under Massachusetts law, they are considered forged. Forgery can be qualified meaning of someone signing your name, but forgery in Massachusetts also includes what other folks might call counterfeiting a document. That is presenting as an original, legal, and enforceable note something that's not original. Out of 78 of the 80 copies I saw, only 78 were legal. 78 were forged. Only a small percentage were actually legal. The vast majority of them are endorsed in what they call in blank. That is an endorsement to no one. And under Uniform Commercial Code, when you're trying to enforce a note against a securitized asset, in this case, the house in a foreclosure, you can't do it without with an endorsement in blank. The transfers have to have been from a particular person to another particular person, not unlike a personal check. I am here testifying because of this nominee, the Honorable Appeals Court Justice Wolohojian, handling of homeowners' rights to see a note potentially demonstrate a void foreclosure. In her first major decision as an appeals court judge in this area, the Paul Norris case, enforced the SJC's decision in its second most famous part of the foreclosure crisis, which was Eaton versus Fannie Mae. That decision said that you have to have an enforceable note and either be the note holder or the agent of the note holder as the mortgagee to foreclose. Therefore, she gave Paul Norris, who I know in discovery, the right to see the original note. Now, there is no point in giving someone discovery if they don't have standing to use what they find in discovery. The Eaton decision was absolutely clear that there had to still be a debt obligation. That is a negotiable note for a foreclosure to go forward. This is only logical since you're taking the house to pay off the debt. Since then, she has had more than a half dozen significant decisions where she reversed JC holding in Eaton and on her own holding in the Norris case and clear law of the Uniform Commercial Code. In the law since 1894, as to negotiable mortgage notes, which was Maryland Maynard versus Bernard. She's made no explanation for why she understood in 2013 and then reversed the law and reversed herself along with the SJC. She wants to be an SJC judge putting down financial interpretation. Number one, she doesn't believe that the SJC puts down financial interpretation, or she wouldn't have reversed her position on the Eaton decision and now put down things that couldn't possibly comport with the Uniform Commercial Code and Eaton.
Ms. Mitchell, I'm going
very
to have to
worried.
ask you to wrap it up. We're at time.
Okay. Given there's 125,000 foreclosures in Massachusetts, which means something like 200,000 households, 500,000 people, why does she not want to take the side of the homeowner and just do what she feels like and not actually enforce the law?
Thank you, Ms. Mitchell. Are there any questions for this witness from members of the council? Seeing none, that will wrap up the testimony. I don't believe we have any other individuals who have requested to speak in opposition or in favor. And so at this point, we will close the witness portion of the hearing. And we are going to take a short break before we hear from our nominee and move forward with the remainder of the hearing. So I have 12:15. Why don't we be back in here at 12:25? We'll take a 10-minute break. Okay. Thank you, everyone.
Hello? No, it seems like it's good. They just took a break. It should come on any second now. But then it just said, so wait a minute. It says video stopped. Okay. All right, if I need you, I'll call you. Bye.
We're going to try and get started, folks. Good afternoon, everyone. Sorry to break up a good party, but we do want to continue with the hearing and make sure we have quantity time for questions and for the nominee's statement. So I think we've got everybody back. I think Counselor Iannella is back as well. We'll go ahead and reconvene. Justice Wolohojian, would you like to present your opening statement at this time?
Yes, I would. Thank you very much, Lieutenant Governor, and the members, the honorable members of the Governor's Council, for giving me this opportunity to speak to you a bit about myself. I also wish to thank you all for taking time to meet with me extensively before this hearing. All of us in this room, and particularly the judges here, fully appreciate the care and thoughtfulness with which you carry out your duty to advise and consent the governor on all judicial appointments. I hope that I will be able to provide you with sufficient information to satisfy you that I merit the governor's confidence in nominating me for appointment to the Supreme Judicial Court. I want to start my biography in 1989 when I graduated from law school. That was the year I clerked for legendary federal district court judge Rhea Zobel. Judge Zobel's courtroom was where I saw law in action for the first time, and the experience hit me like a bolt of lightning. This was back in the days when cases were being regularly tried, and so I got almost a daily opportunity to watch cases in court. I saw lawyers, whether from large firms, small firms, as solo practitioners, government lawyers, prosecutors, or defense attorneys, bringing their skills and advocacy to advance their clients' interests, protect their clients' rights, and defend their clients from harm. At the same time, I saw the judge poised in the middle, deftly and pragmatically, always with a light touch, politely but firmly move the case forward in a practical way. That early experience of seeing the judicial system at its best left a permanent mark on me, not least because it lit a very early hope that I too someday could become a judge. But no one becomes a judge straight out of law school. And the first step to becoming a good judge is to become a good lawyer. So after a second clerkship, I joined Hale & Dorr in its litigation department. There, at the knee of well-known trial lawyers such as Jerry Fasher and Joan Lukey, I learned the mixture of craft, skill, and art that is required to be a good trial lawyer. How to write a brief, how to conduct discovery, how to examine a witness, how to deal with clients, how to be civil to opposing counsel even when litigating vigorously against them. the importance of being trustworthy and honest in one's dealings with colleagues, clients, opposing counsel, and the court. I learned those same lessons working for Bob Fisk on the Whitewater investigation. And I also learned what it means to appear before good judges and those who aren't so good. I learned how a good judge helps the lawyers achieve the best result that can be achieved, never standing in the way or putting their finger on the scale or making the courtroom about themselves. A good judge listens. A good judge is fair. A good judge is prepared. And I learned that when you walk away from a good judge's courtroom, your confidence in the justice system is renewed, even if you lost your cause on that particular day. After 18 years in private practice, representing both plaintiffs and defendants in complex civil litigation, I had the great good fortune and privilege to be appointed to the appeals court by Governor Patrick in 2007. I have approached every day since then with an eye towards being the kind of judge I wanted to appear before when I was a lawyer. It has been my goal to try to engage the lawyers and my fellow judges in a joint effort aimed at getting to the right answer. I like to think that the right answer can always be found if you work hard enough to find it. But to do that, you must set aside your preconceptions. You must approach the law honestly and openly. You must listen to the litigants with respect and patience, and you must humbly do your homework by delving into the record, researching the law, and mastering the facts. You must listen to the views of your colleagues, and you must test your thinking against theirs. And once all of that is finished, you must measure your conclusion against your sense of fairness and justice. I try to write decisions that are clear, succinct, and written in language that lay people can understand. I want the parties to know not only that they were heard, but also to understand the reasons why the case is coming out the way it is. That is the process that I have strived to follow in every case for the past 16 years. And I have done so because I want to earn every day the immense privilege and responsibility of deciding the problems people have brought to court for resolution. These include the issues dearest to them: their liberty, their families, and their welfare. In addition to deciding cases, I have also tried to do my part to improve the way the court functions. I believe we can always find ways to do better. And frankly, we owe it to our community to do so. I won't go into too much detail, but I'd like to summarize some of the projects and committees with which I've become involved in an effort to make things work better. The most satisfying of these has been to head up the mentorship program for new judges at the appeals court. This program helps new judges become acclimated not only to the court's procedures and policies, but to adopt as their own the mindset of collaboration and excellence. I have also been deeply engaged in various committees designed to improve the court's policies and procedures, including leading the significant work that led to the court's current en banc pilot program. I have also gotten involved in efforts to make the experience of the court system better for its users. For example, I chaired the Committee on Plain English Jury Instructions, and I am chair of the SJC's Standing Advisory Committee on Appellate Rules, where we are constantly attempting to simplify and clarify how appeals are handled. And finally, after receiving a brief in a case last year that was prepared with the assistance of generative AI, I have been leading a committee to advise the SJC on this transformative technology and what it might mean for the courts and the practice of law. In short, I have rolled up my sleeves and tried to help in areas wherever I have believed that improvements could be made to the system. In closing, I would like to turn from talking about what I have done and to spend a moment to explain why I left private practice in order to spend the remainder of my career in public service. In 1915, the Ottoman Empire launched a genocide against its own Armenian community. The survivors were dispersed around the world and settled in countries where they hoped they could find safety and a better life. Two of those survivors, Mugerditch and Mendui, realized that hope in Massachusetts. In this great state, they found a well-regulated society based on the rule of law. And it is here that their granddaughter tries to pay back that debt by doing her part to preserve it. Thank you for your attention and consideration. And I also wish to thank Valerie McCarthy and her staff.
Thank you, Justice Wolohojian. We now will open up our council for questioning from counselors. We're going to start with Counselor Devaney, your host counselor. And I just want to remind everyone, we've got up to 15 minutes per counselor for the Q&A sessions. And go ahead, Counselor Devaney, the floor is yours.
Welcome. Nice to see you. 16 years ago, I presided over your hearing as your district counselor, 16 years. And you have an amazing accomplishment that you have done. We've got so many letters, but I do want to point out that every time I have a nominee before me going to the appeals court, I bring up your classic decision on Peppermint, the dog. And I'd like you people to know that because I think it's very amazing. She changed the law that was in fact, how long was that? Decades and decades.
It was the common law. I think it was actually for centuries.
Right. So there you go. And what happened was a woman had her little dog on her lawn, and a man came by with two dogs. One was on a leash, and the German Shepherd was loose. The German Shepherd ran on the lawn and attacked this little dog, little Peppermint, brutally. Luckily, she survived. She had surgery. And I think it was about $8,000 that the owner had to pay. So she sued the owner of the dog. And the district judge ruled that Peppermint dog was property. So this case went before you and you won. And the woman got her $8,000 for the surgery. I think that's remarkable. I really do. And as an animal lover, I thought it was great. So we've got so many letters. I wish I could read them all from all the judges, from people in the district. It really is amazing. I've never seen anything like it. And I do want to say that it's so impressive how many appeals you've had, how many decisions, how many cases. Tell us, how many cases have you had?
I've sat on 2,700 cases approximately. I've written 900 decisions. There are 3 people on a panel, so we divvy them up, so we each get a third every time.
Mm-hmm.
And as you know, Counselor, we have both unpublished decisions and published opinions. Of those 900 decisions, 125 at least were published.
That has to be break the record, really. I've never in 25 years seen that. Now, tell me, what do you have made a lot of changes and it's been noted by people who have written letters about you and several ways that you have improved the appeals court in mentoring people and also maybe you could tell us, instead of me saying it, some of the changes that you've made, the improvements.
Sure. I think the most important to me has been the mentoring program, because I remember how long it took me to learn how to assimilate myself into the appeals court. And I had a mentor at that time, Judge Drebin, and how important the mentorship was. And I've had mentors throughout my career who have helped me all along the way. And I really believe that we're each just on the chain. We receive, and then we're supposed to give forward to the younger lawyers. And so I wanted to make sure that we reinstituted a mentorship program for the incoming judges. And selfishly, I did it because better trained judges are better to sit with. So if I have a better trained colleague, I feel like we're all in a better shape.
Right. You know, I was impressed because you developed training and mentorship programs for new judges. You established an annual continuing education procedures and rules. And, you know, I asked you when we met again, what are the needs? There's still some needs to be met on the appeals court. What do you think? What change could be added?
So we have an absolutely terrific bench and we have a first-rate staff. I would say, though, that the appeals court handles the lion's share of appeals from the probate and family court. And we have a terrific, I don't want to call it graduate, but Justice Blake was formerly a probate and family court judge. But she's only one person who's on our court with that expertise. And personally, I feel that we could use another one.
Okay. And you've had a lot of publications. What was the most rewarding publication that you wrote?
I think actually it was just a publication for judges, but for a couple of years, including with Judge Botsford, and this was carried on by others later on, there was an annual review of appellate judges, of appellate decisions, the SJC decisions and the appeals court decisions, that we would collect, highlight the important ones, and then go and make presentations to the trial court judges with the idea that it would assist them in seeing the highlights or the significant developments in the past year and make it easier for them to know what they were.
When you think of 2,700 cases, appeals, is there one that comes in the 16 years that you'll always remember and was the most difficult and yet the result was rewarding?
Well, what I would say, Counselor, is the cases that I remember the most are the cases that make me the most sad. And it's not about a particular legal issue. It's about who was involved and what happened to them. And cases that involve children, and particularly children who are victimized, you just never forget them. And they are heartbreaking, and there's nothing we can do to solve it, but it really stays with you.
Well, I have to say, in 25 years, I've never seen a resume like this. And what you're bringing to the SJC. And I want people to know, we don't know who applies to these positions. We don't know how many, we don't know who they are, we don't know how many are rejected, how many get an interview. But I do know, digging, that you did apply in the Baker administration. And when you did, you were rated #1 by the SJC Screening Committee, by the Judicial Nominating Committee Screening Committee, and other committees that, you know, that looked at your resume. And you didn't get it. You didn't get the position. So I am thanking you personally for doing it again. And I want a message out there to all people who were rejected in the Baker administration: apply again. because I've seen so many good people along the way who have been rejected. And then they see someone not so qualified that gets a job, they won't apply again. So I'm giving you the message. It's a whole different open government apply. So having done that, I'll get off my bench. But I do want to say that the letters that I got all said the same thing, how you were open to everyone and helping, and that you compromise. And all of that, you know, to me is so important. And what do you, is there anything, any challenge going from the appeals court to the SJC that you see?
Well, I can't actually believe that I will ever have better colleagues than I've had on the appeals court. And I also worry about the psychological and emotional toll of the first-degree murder cases. Those are the hardest of the hard, and the most heartrending of the facts. And, you know, that's the front line for judges. We get immersed in these terrible cases. We develop a sort of intimacy with the factual record that inevitably gets under your skin to some degree.
But there seems to be the same type of respect that I see in all the letters about the person you are. And so many judges, and Lieutenant Governor did mention some of them, but one of them, and Justice Agnes, he talked about how you have those things that a judge should have, talking about courtesy, dignity, patience, tact, free from arrogance, not impatient, not prejudice, not bias, and willing to listen and keep an open mind. And he mentioned that that was Justice Edward Hennessy who said that. And you fit it perfectly. And he said in the letter. And he summed it up by saying, we sell justice to no one. We deny justice to no one. You know that. So what would you want people out there to know about you taking this position? I mean, people really don't understand the journey that you've taken. And 16 years is amazing. And I've seen people going to the SJC, not a judge, very qualified, but not even a judge. But I'm saying, how do you think that makes you so more qualified?
Well, obviously, the work of an appellate judge in terms of how you do the work, what's required to do the work, decide appellate cases, that would be essentially the same as I've been doing on the appeals court. The appeals court gets cases, murder cases, to the other end of the spectrum. I think I mentioned to you previously when you asked me where was the other end of the spectrum, I said I literally have once had an appeal of a water bill. So from water bill to murder. And the process of how you decide an appeal is the same every time. It's about understanding the party's arguments, delving into the record, doing the research, writing the decision, talking to your colleagues, reaching an agreement, hearing oral argument. It's all the same. Obviously, the types of issues that come before the SJC are oftentimes different.
And you're noted for going the extra mile, even if you're not on a panel, you get involved and you look into that and help and comment and recommend. I think
Some might
that,
call me a nudge.
that's great, yeah. And I think, you know, that's part of it, working with the rest of the judges. And you have done that in your career. So is there any reservation that you feel going into this? You must feel very confident.
I don't feel confident, actually. I only have confidence in my willingness to work as hard as I can. That's the only thing I have confidence in. And then I hope the rest will work itself out.
Right. So, different people have reason to not to be able to vote on certain issues or whatever. Do you see any of that?
I'm sorry, I didn't
Do you
hear
see
the
that,
question.
some people, when they go to these different courts, I've seen that they recuse themselves on different issues. Is there any matter that would ever come up, do you think, that you would have to do that?
Well, there certainly could be. Recusal is something that I take very seriously. It's a two-sided question. There are cases in which you need to recuse yourself, and you do so. And then there are cases where you don't recuse yourself, and you don't do so. That is a case-by-case analysis. Every judge does it for every case. I do it now for every case. I will continue to do that for every case. You look at the circumstances of the case and you determine whether or not there's a need to recuse. I want to add here that I think for those of us who are judges and lawyers, we understand that there's a danger in over recusal as well as a danger in under recusal. You're trying to get recusal right, and that you can only do by looking at each case individually. I have absolutely no interest and never have in sitting on cases I shouldn't sit on or not sitting in cases I should sit on.
Well, you're,
Counselor Devaney,
I
you have
know you
limited time
16
left.
years, and I've seen it. I've seen you recuse yourself, and I admire your honesty and your independence. And I thank you for this, and congratulations.
Oh, thank you very much, Counselor.
Thank you, Counselor Devaney. Next up is Counselor Iannella, who will be joining us virtually.
Thank you very much. Thank you. Good to see you, Justice Wolohojian. Can you hear me?
We can see you, Chris.
But can you hear me?
Yes, we can hear you as well.
Okay. Justice, it was, I think, 16 years ago, you came before the council when you were first appointed by Governor Deval Patrick. I recall at that time, you had a quite impressive academic career. You went to Phillips Academy, then I think Rutgers, Oxford University in England. Then you went to Columbia Law School. You were on the law review. Quite impressive credentials. And then after
At that point, my parents were hoping I was going to get a job.
Well, you got one soon after that. You're a clerk in the district court of appeals with Bailey Aldridge, and prior to that with Judge Rhea Zobel. Then there's no question you worked with a distinguished law firm, Hale and Dorr. Now I believe they're called Wilmer Hale. So I'm familiar with your record up until that point. Then you came before us, I think 2008. I was on the council at that time. The council unanimously, everyone, supported your nomination. But since then, I really haven't followed your legal career and since you've been a justice of the appeals court. So my question is, while you've been on the appeals court, Councilor Devaney asked you if you had any publications. Do you have any committees or anything that you were involved with while on the appeals court?
Oh, my goodness, Counselor, thank you for that question, but I'm worried that this is going to be a very long hearing if we go into them all. I am like those overscheduled 13-year-olds who gets involved in every after-school activity and every possible committee in the court system, it seems almost that I have been involved in.
Well, can you name a few, the ones?
Sure. So I have been at the appeals court, and I may resort to some notes on this, but I have been on the appeals court, proud member of the social committee. If we can only have pictures from there, that would be a great portfolio. I have, though, also been the head of the Policies and Procedures Committee, where we have tried to record and make public, which I think as a court and with Chief Justice Green's leadership, that was a huge step to make our internal policies and procedures available to the public. But developing those policies and procedures is a committee that I chaired. I have chaired a long and sometimes difficult process of the court exploring an alternative to the procedure under Shaba, and where we are now, as a result, in a pilot program testing an en banc procedure as an alternative. I've been the chair of the mentoring program. I draft the new judges manual in connection with that. For a while, I chaired the education committee, so that there was, that was targeted towards educating our judges after they were sort of new. And I think that may be my appeals court committees. I've also, though, been on various SJC led committees, the Committee on Lawyer Wellbeing, in which I was the judicial representative. I was on the Standing Advisory Committee of the Rules of Civil Procedure. And during that time, I was part of a group that overhauled for the first time in 30 years the appellate rules. From that, then spun off a new Standing Advisory Committee to the SJC for appellate rules. I've been the chair of that committee since it began. I was the co-chair of a SJC committee on plain English jury instructions that lasted for several years. And then I think actually the Superior Court judge, because Justice Douglas Wilkins, I think, was very involved with that on the Superior Court. And we collaborated in some trainings and programs on that. I may be forgetting some. I'm sorry.
No, that's enough. That's enough.
Yeah, that's what my colleagues said too.
Councilor Devaney alluded to the fact that you applied for an SJC position in 2016 with the Baker administration. And my understanding is that you came so close. I know you didn't get it, but you had an interview even with the governor and lieutenant governor. You were like right on the doorstep, but unfortunately for you, you didn't get it. Is that correct?
That is true.
Okay, that's fine. To me, that I'm most impressed about is the fact that you wrote 900 decisions. And we know not every decision is appealed to the SJC. We know that. But of those 900 decisions, only 2 or 3 were reversed. Is that correct?
That's true. Those 2 or 3 may have been wrong, I think. I mean, SJC decision. But it is true that I have, on a small number of occasions, been reversed. Justice Blake, who's, I think, actually took a statistics course not that long ago, has calculated my reversal rate as being statistically 0.
That's pretty damn good. That's pretty damn good.
I think that's the lay term.
Yeah. You know, let me say this. I voted for you 16 years ago. I voted for you because I thought you were definitely qualified. And let me tell you, nothing has changed over those 16 years. You are the real deal. You're compassionate. You know, you have the right temperament. And a lot of people come before this council, and I can honestly tell you, you seem like a really nice person, a decent person. That coupled with your legal career, I can tell you when your name becomes before the council, either next week or the following week, I'll be more than happy to support you.
Thank you, Counselor.
Thank you, Councilor Ionella. Next up is Councilor Eileen Duff.
Thank you, Governor. Good to see you, Judge. I'm glad actually you mentioned something that we didn't speak about at all, but is very important to me, and I think important for everyone in this room, is lawyer well-being and judge well-being. It's something I've talked about in the past. I'm not going to go into it today, but thank you for for mentioning that, because it's something we don't talk about or I think give enough attention to. But to get to the questions I have for you for this job, what is your approach to separation of powers? For instance, what's the judicial role in policing the executive branch relative to what occurs naturally?
Did you say relative to what occurs? What was the last word?
How it naturally occurs to natural interactions with them, or let me rephrase it. How do you view or consider our issued a civil action imposing a sanction in the case I'm holding in my hand, citing the increasing tendency of the popularity of generative artificial intelligence and the ability to fabricate in supply false and misleading information. It is, we hear about it in high schools, in essays and things like this, but the way this has already begun to impact the court system, I think we haven't even scratched the surface.
All right, and if we also consider how busy the trial court judges are and how difficult it's going to be for them to try to get behind that, it's really scary.
Do you have any knowledge of, the general public, we know about Chat GPT and Google Bard and things like that. Do you have any thoughts or knowledge of legal AI that's being developed or has started being developed, that how and what it is, the cost, because I would expect it might be costly, and how that may change or impact the legal system, not just as a judge, but just as the law and as the courts in law firms as we know them today?
Yes, and my understanding about this, I'm still in the process of educating myself as well. But there are very expensive tools, legal tools using generative AI that are being developed and marketed by completely reputable firms such as Thomson Reuters, LexisNexis. They are very expensive to develop. They're very expensive to pay for. Right now, they're probably only in the reach of the very largest law firms. There's a concern, there are multiple concerns about that. There's the concern about how that gets built into fees being charged to clients. There's also the concern, when I first started learning about generative AI, I thought this is going to be fantastic because unrepresented litigants and one solo or small firm lawyers are going to have access to this tool that's going to help them produce filings, help them review documents for discovery. But let's call it free AI is unreliable. And that's what they're going to use. And it's going to produce hallucinations. There are pitfalls about whether you need client consent. We need to educate lawyers about what's going to happen to the information that they feed into the AI tool, because they may not understand the implications of the technology and what may happen to the information that they're feeding into it. So I'm concerned that over the long term, counterintuitively, generative AI may widen the gap between those who can afford it and those who can't. So it becomes an access to justice issue.
Thank you. Because it seems to me that if only, the biggest firms can afford a subscription to this, we're almost going to see monopolies in law firms start, of where they can afford it and the smaller firms or solo practitioners cannot. And in those big firms, what does it do? Does it start to replace, paralegals and clerks? I don't know, but do you have thoughts on that?
I do. I mean, I think we have to recognize that the large firms have resources that the small firms simply cannot duplicate and their clients cannot afford. And that includes even setting aside AI. There are small firms that can't afford to use Westlaw or LexisNexis. Right. This is just going to be another but extremely important version of that existing dichotomy.
Thank you. Let me see. I'm not going to ask you any more questions. I've read a lot of your work and a lot of your writings. I've, only frankly ever met you 2 times. But you are so qualified to be on this court. I'm excited that you applied. I know it's been controversial in some circles, but, you know, A players hire A players. And that's what I think we're doing right now. We do in Massachusetts have the best court system in the United States. And we want to have the best and brightest, and it's not easy. You know, clearly someone like you, I didn't know when I, you know, approached you about some of the issues I'm interested in that you are already working on this stuff. And so it just shows to me you are on the cutting edge of things, and you're deeply concerned. You could be making so much more money in private practice, frankly. So thank you for your willingness to serve the Commonwealth. I don't think people understand what people who are as smart as you, what you give up to serve us.
It's an honor and a privilege to serve on the courts of Massachusetts, Counselor.
Thank you, Judge. That's all.
Thank you, Counselor Duff. Next up is Counselor Kennedy.
That's where I was going to begin, what you gave up by going into public service. You were at pretty much the largest law firm in the Commonwealth of Massachusetts. I suspect that your contemporaries in that firm have made a lot of money while you've been in the appeals court, and that you've given up, I guess, millions of dollars to.
Don't let my mother hear that.
The point is, you made a great sacrifice for your public service, and you're continuing to do that with this application. You know, one of the things that people don't know is that in 2016, when you applied, Councilor Duff and I sat down with you to encourage you to apply at that time. We had lunch down at the Kinsdale, where we both thought you would be terrific on the SJC. Nothing's changed in my mind with respect to that, and I'm happy that you applied again. I do want to talk to you about a couple of things, and I'm not going to take up a lot of time. I was very curious about the Artificial Intelligence Committee that you were on. I saw that in your application. And I'm curious what the committee actually does. I mean, it's brand new. It's the last year and a half, 2 years, all of a sudden it's exploded in the world. I don't completely understand it. I have to rely, over the last 20 years with computers and technology, I've had to rely on my kids to help me out with that. My daughter's over there. She did a lot of that stuff for me. But what exactly was the committee doing?
So we've been charged with making recommendations to the SJC justices as to how to proceed, is the way I would best put it. So we've, so far, what we've done is I organized, I would call it a small conference, to hear from the technology side, the experts in the technology, to educate our committee. And now we've identified the major legal issues that we think will be important to the SJC. And roughly they are legal ethics, legal education, the judiciary and the use of AI in the judicial branch. And I believe there's one more, but I can't remember what the working groups were that I created. And then we're going to split out. I think where we're going to end up is to recommend that that there be some acknowledgement, even if not rule change. A large part of it will be education to lawyers to make sure they don't just start using this technology without understanding its pitfalls. And then somehow, I think we need to think about how to educate the general population, even if only through policy statements, that it looks like it's a very seductive technology. It looks like, oh, it can write a brief for you. But you may be harmed by that brief because the judge may sanction you for filing a brief that has false information in it.
Well, if they learn that, if artificial intelligence learns to do it right, they don't need me in a courtroom anymore. That's the problem.
No, they'll always need you.
But just in terms of that, you're looking at the negative aspects of it. Have you looked at what the positive aspects of it, where it can be helpful in the judiciary?
Well, I can tell you what the developers of the AI have told me are the positive aspects, and then probably you'd have to use a grain of salt to figure out where you fall on that. It can review huge amounts of information. So let's say you had, like in the appeals court, we'll have a brief supported by 13 volumes of appendices, and I have to read those 13 volumes of appendices. Maybe that's 800 pages or whatever. It's a huge amount of volume of work. Or you have tried a multi-day murder case and there are 27 volumes of trial transcript. And AI can read that. I mean, maybe read is not the right, but I'm anthropomorphizing this technology, but it will read it, it will summarize it. And then the question becomes, so that could be a huge boon to a judge. Now, the developers will tell you it's 100% accurate. My question is, how are you going to know unless a human being actually reviews the trial transcript as well? But the temptation to use it, especially when judges are so overworked, is going to be huge. Are we comfortable with judges using AI to make findings? I mean, these are really big questions.
No, they are. And they're not gonna be my problem because by the time it really gets in full swing, I don't think I'll be practicing law then. But anyway, one of the issues I raised with the earlier nominee, governor's earlier nominee for the SJC, was the fact that she'd never actually been a trial judge. And I was trying to think about that in terms of how the SJC is currently constituted in terms of that. I know that Judge Gaziano was a trial judge. I know Judge Bud was, and I know Judge Georges was. I appeared in front of all of them when they were trial judges. I don't believe Judge Kafka was.
No.
I'm trying to remember the others if they were or not, but how important do you think it is? I mean, you're judging the judges. You're judging judges that are making, in a lot of cases, snap decisions on the spur of the moment during the course of what might be a contentious trial. They get it wrong sometimes. Sometimes they don't get it that wrong. Sometimes they get it really wrong. But how do you manage to make those decisions without ever actually having sat in that seat?
I understand that question, and it feels personal to me too, because I got onto the appeals court without having been a trial court judge. And I will say it's definitely been a piece of my own learning curve. It helped me immeasurably to have been in courtrooms for 18 years before I got on the bench. But the trick to everything is that there is judicial discretion. And the difficulty I have found is learning where the outer bounds of discretion are. And that, I think, really does come from experience. And I feel that that's something that I've really learned. And you just have to look carefully at what the judge did and evaluate it in the context of that case.
Okay. And I do want to touch on the issues dealing with exculpatory evidence by prosecutors. I know you addressed it a little bit, but it's been an ongoing problem for the last 10 or 15 years. Judge Brennan spent a very long time, Justice Brennan, who's sitting in the back, working on all the Drager cases, dealing with the operating under the influence cases. We had the whole drug scandal, both here and out in Western Massachusetts. We had this issue with the AG's office where some prosecutors withheld some exculpatory evidence. It seems that the message isn't getting there about exculpatory evidence and what the obligations are. I know a recent decision came down, but it's not just about a decision. It's getting the message that it has to happen. The drug cases, the remedy was an extreme one. They threw them all out. The Drager decision wasn't as extreme. We seem to have pulled back. And that was a case where it wasn't so much the particular prosecutor's offices that was withholding the evidence, the exculpatory evidence. It was the Office of Alcohol Testing. But they own it. The prosecutors own it. How are we going to get the message across that this just can't keep getting repeated and repeated and repeated? And that's going to be your issue on the SJC. How are you going to send a message that you can't withhold exculpatory evidence?
So, I I think this, like so many other problems, are best rectified on the front end, right? You want those decisions to be made correctly by the prosecutors.
Why?
It's
That-
hard,
let
and
me-
the
let me just-
only
let me
way,
just follow on that. Why should the prosecutor be looking at documents and looking at statements and looking at this and that and say, well, I think this is exculpatory, I'll turn it over. I don't think this is, so I'm not going to turn it over. Why don't I get, I'm a defense lawyer. Why don't I get everything? Just
you
give it
know,
all to me.
many prosecutors, I think with the exception of privilege, turn over everything.
Sure.
Those are
And by the way,
those are
I
the
think
good
that's
ones.
true with 99.9% of them.
Yeah.
I don't want to suggest otherwise. 99.9% of the prosecutors I've dealt with absolutely give me 100% and go above and beyond. I want to be clear about that.
Yeah, and I think the best solution to these things is education, whether it's within the DA's offices or otherwise, because when it gets up to the courts, all we can do is look retrospectively, and our tools are backwards looking, like exclude the evidence or reverse the conviction. And in the ideal world, that's not where it's supposed to be solved. It's supposed to be solved on the front end so that the defense gets the documents it's supposed to get.
Okay, and just the last issue I wanted to talk to you about is, and I've seen it, I go to virtually every court in the Commonwealth on a regular basis, and I think there's a real morale problem going on in the court system right now, with the judges, with the clerks, with the staff. And I'm not sure why it is, but I definitely see it and feel it, and I talk to people. I have a tendency to spend a lot of time with court personnel. And you don't really have to comment on it, but I want you to think about that. I had a conversation with Justice Butt about that recently, because I think it's becoming a real issue, and I think it has to be addressed. Now, I received countless phone calls and emails about you, that the vast majority of them were favorable. There was a few that were concerned about the optics of the nomination, but not about your qualifications. Nobody said that. And the one thing that came across in all of those conversations about you was humility. So given the current constitution of the SJC, I'm not sure you're going to fit in.
Don't make me touch that.
No, but that's what came across over and over and over, was humility, humility, humility. And I saw it when we sat down. It was clearly there. You actually said to me you were kind of embarrassed by all the attention and the press
Yeah.
involved in this, that you wish it was more low key. And I'm sure you do. I think you're a terrific candidate. If people look at nothing but your qualifications, there's nothing to talk about. I'll be voting for you next week.
Thank you, Counselor.
Thank you, Counselor Kennedy. Next up is Counselor DePaulo.
There it is. Good afternoon, Justice. Thank you for coming to Worcester. We had a good conversation. We talked about some of the keystone things that constituents reach out to me and probably some of my colleagues about, reassuring us that Massachusetts residents can continue to enjoy the rights and privileges that we've come to expect regardless of what happens at the national level, ensuring that the public has faith in our institutions because when appropriate and where appropriate, recusals happen. And we talked a little bit about AI, which I won't get into again, but I found that interesting. Another issue that I think companions with AI, and maybe it's duplicative, so please be brief if so, but obviously technology continues to emerge. And just very, very recently, the SJC came down with a decision, Arrington, I don't know the pronunciation, but around it was location frequency history or frequency location history in a cell phone. And that in that instance, the Commonwealth, the court found the Commonwealth had not met its burden under Daubert-Lanian to introduce that. is this an area, are there other areas in emergent technology besides AI that are on your radar as far as what you're going to see on the SJC if you are seated there?
Well, if I'm lucky to get there, I'm not going to be reviewing this case, but the
No.
SJC recently granted further appellate review on a case I wrote that involved an emerging technology on a cell phone and police officers surveillance. I think technology is going to be providing new problems in cases because it is changing so quickly and being used for so many different things all the time. Video, audio, location, biometrics. I don't think we've had a biometrics case yet. I don't know what that might look like. It is my fervent hope that lawyers will be able and have the resources, particularly in the criminal side of the docket, to hire the experts, develop the record that would allow us to find out whether the evidence meets the Daubert-Lanigan reliability test.
And perhaps you just addressed this, but likewise with the AI, should we be concerned about an asymmetry of resources? And I suppose that's
Definitely.
what you're alluding to.
Definitely.
On this issue, having been on the bench and obviously having been a practitioner at a high level, have you seen analogous emerging technologies, or have you seen technologies emerge in your time where things changed drastically?
Are you connecting it particularly to disparity of resources or just new technologies?
Well, new technologies in general, and then I would like to hear whether disparities in resources played out in a meaningful way.
Okay, so the new technology that I would say, the two big ones in my view are the cell phone and the ability to track people everywhere all the time. I mean, those are huge. And when I was growing up, you could get lost. Like your parents couldn't find you. You could just like go down the street and they couldn't find you.
I just explained to my oldest daughter the other day that the strap on the visor, when you're sitting in the car on the windshield, people used to put maps in there. She said, "What in the heck is this for?" And she found it was good for vlogging, live vlogging our drive to school, but it had other uses. But so, I mean, but on these issues, as they emerged, do you have an analogous experience that you look back on in your legal career where the technology came and the court struggled at first with what to do about it and resolution was reached?
Sure, I think, and you can see this in the US Supreme Court decisions, GPS data was very difficult to figure out where the parameters between that and what's an unreasonable search and seizure. Was very, very interesting in the early days. I still think it's probably very interesting. Some of these technologies, when they're used by state actors, implicate the Fourth Amendment clearly. So you need to be thinking about those issues. There are obviously privacy issues that we struggle with emerging technology, particularly the kind that's coming around now. I remember reading, and I just don't know if anything actually came of this or if it's like one of those things, urban legends on the internet, that one of the cable TV providers had the ability, although they had not turned it on, to have the TV recording when you put in your cable box, that it could also record what was happening in your room when you were viewing it. That sort of freaked me out to think about that. So there are lots of technologies out there. We don't really understand them all. We need them to be teed up in cases and to figure out how the law is going to deal with them.
I'm grateful and not surprised that our courts are on top of this and are forward-looking on these issues. Councillor Duff brought up separation of powers. You and I talked about the Mattis decision a little bit. Do you believe Mattis was decided appropriately?
So Mattis is the law. I would follow Mattis, and I think the majority got it right.
So Mattis, for anyone who doesn't know, is the recent case where life without parole for so-called emerging adults didn't pass constitutional muster under Massachusetts Constitution. And the three of the fact, without getting into the details of this case, and I know you would run circles around me if I were to get into the legal points, but the court said we need to consider that youthful characteristics need to be considered in sentencing, that brains of emerging adults are more like juveniles in some ways than like adults, and that contemporary standards of decency are one of the factors that helps them arrive at this decision. And two of those are sort of constantly in flux, the science and as well as the contemporary standards of decency. So if the brain of a 19 or 20-year-old or 18 or 19-year-old can be demonstrated to be more similar to a juvenile than an adult, and if the science were to demonstrate that someone who's experienced childhood trauma would have that delay or that development would be delayed beyond a typical person or a similarly situated person without extreme childhood trauma or complex childhood trauma, would it follow that because their brains they're situated the same as these other folks in the Mattis case, would it follow that there's a possibility that this expands in that and perhaps many other directions?
I don't like necessarily the way you phrased that question, or maybe I'm not allowed to just
This is why I say, please run
I'm not
circles
allowed to opine on the quality of your question. What I would say is the science needs to be considered. If the science shows something, then I would consider the science. I recognize that childhood trauma is a serious problem, and there are many children who experience it, and it affects them in pervasive ways. And we see that in our cases all the time. How that will affect a constitutional analysis of what is a lawful sentence for young people who commit serious, if not the most serious crimes, I don't know. I think I'd have to wait for the case to see what the science says and take it from there.
Sure. I mean, in the Mattis decision, the court noted that the three characteristics that Dachenko had identified as distinguishing those juveniles in that case were present. And so I would imagine if those same factors continue to be present, then there's the possibility for that, yes?
I'm sorry to say this, but actually there's some words that I don't catch when you're speaking. I can't hear them.
Okay.
Yeah, sorry. So you said in Mattis there were two, but then I didn't hear what came after two.
That in Mattis, the court harkened back to Dachenko and noted that the defendants in Mattis demonstrated the same three characteristics as the defendants in Dachenko. And thus we arrive at that decision with obviously more complex reasoning layered on top of it. And so if those three same characteristics continue to be present, it would seem to follow that there's an argument that this would become something that will continue to evolve.
There's always an argument.
You wrote in your application that your greatest professional disappointment is that in your power as a judge, you often can't cure the party's problems, it's acute, particularly in the regard when children are at the center of the cases. And then we talked a little bit and you wrote about perhaps for your next phase of your career after your time on the bench that may be an area you look to work in improving children's lives. But, and what I imparted to you yesterday and why I'm so grateful to be a resident of Massachusetts, the Mattis decision is impacting people right now. The courts have done that. And as I expressed to you, the folks who Governor Baker commuted a couple of years ago, and I dwell on the example of William Allen, who I'm regularly in touch with, the folks in the incarcerated population in our Commonwealth, they know the name William Allen. And it's not a touchy-feely, hard to understand phenomenon. There's new attitudes and new hope in our correctional facilities today because of that. because of the commutations, because of the Mattis case and the cohort of folks who are now eligible potentially to have a parole hearing. That's great for our correctional institutions, and it's great for our justice system. And just to be clear on this issue, of course, in Massachusetts, our courts and I'd say our politicians, we don't want violent criminals to be released. What we want is that a justice system where redemption is possible. And when young people commit serious crimes, that we hold hope that there is hope for redemption. And when those folks become eligible for parole, the parole board may very well see that it's not appropriate to release them. That's a very likely possibility. But the hope changes things. And so I'm grateful for the courts. And I feel that should you take the seat on the SJC, that you'll help continue that tradition in Massachusetts.
Thank you.
Thank you. I have no further questions.
Thank you, Counselor DiPaolo. Next up is Counselor Jacobs. We're finally getting to this side of the room again.
Well, hello. It's good to see you.
Nice to see you too.
I want to start by saying I want to thank you for sitting down with me and the time you gave. I'm almost embarrassed to acknowledge we talked for over 4 hours in your office at the
I
appeals
think
court.
almost 5 hours, Counselor.
It went on that long because it was just such a dynamic, fascinating, engaging conversation.
And it was a non-snow day.
The non-Snowmageddon day. And we covered so many things, some of which I do want to address with you again. And I want to start by saying how much I share what's been said today, that your resume, your experience, the way you present yourself only confirms what I've heard from so many and has been said today about who you are as a person. Not only clearly incredibly smart, but kind and humble and generous of spirit and compassionate. And the list goes on, but the language used about you is consistent across the board. Having said that, my inbox has been flooded. My cell phone has been flooded. Even snail mail has come my way. And it's mixed. There's, as evidenced today by your colleagues here, you have the respect and your qualifications are unchallenged. It's shared across the board. Having said that, I've also heard from judges, lawyers, legislators, many of whom are lawyers themselves, and just people, who, if they know of you, confirm the respect and the clearly qualified impression, but are concerned about, and I kind of put a line in it, almost compartmentalize it, who you are as a candidate and the stellar qualities you bring, and the context of your nomination and the elephant in the room that hasn't been much addressed, but the appearance of, and it's an open question of what, appearance of impropriety, appearance of conflict of interest, appearance of favoritism, or, but there's optics here. And it's troubled me, and it's been reflected from others. And having said that, I have truly struggled with it. And so in service to that struggle, I've spent an inordinate amount of time reading and talking to people to gain more information. And that, just to read you a short list of some, this isn't even of the Google searches go on and on and on, but just to give you a sense of the pathway that I followed. I've literally read the Mass General Laws about nepotism, and there's an additional 1986 advisory about nepotism that talks about what nepotism is, and this is not that. I've talked to 2 different professors at law schools, one in Massachusetts and one in New York, who teach ethics and are experts on ethics. I've read a number of papers from different law schools on judicial ethics and impropriety and specific legal codes of conduct and what have you. And there's a bit of research that was done by the Ohio State Law Journal. The study is For Appearance's Sake, an empirical study of public perceptions of ethical dilemmas in the legal profession. And it's not apples to apples. They didn't ask this question. But having said that, they studied amongst over 700 lay people how the appearance of credibility and integrity of the courts is impacted by scenarios, situational scenarios, and they corrected for many factors. It's a very well conducted bit of research. And the baseline level of credibility in the courts is not what we would hope. It was at like 60-something%. And I don't want to quote exact the statistics, I didn't retain them all, but they were statistically significantly impacted by each scenario, and sometimes to 17-point drop immediately with one scenario based on an appearance. And so my concern of why this has been something I've struggled with is that I wanted to do work like this because the judicial system is so important to me, and I want to do this work in an effort to be a part of our judicial system improving in terms of racial disparities and other things that drove me to this work. And I will also just backtrack just to say I've done everything I can to remain open-minded and objective in the pursuit of this information. So I haven't come to any determinations about it. I've literally just been in the struggle of it, of thinking it through. But the optics matter to me because, there's the perception of our courts being, having integrity, having trust in our courts. I'm from Western Massachusetts. There's the regional inequity element of it, that we have no representation at the SJC. And was there an equal opportunity across the board for those who weren't in, what could be called a deep insider to get the nomination? You and I talked about the recusal question. And I wonder if the recusal question ever could pose a challenge at the court, where an otherwise split decision, if you were to recuse yourself, might end up with tied and an injustice happen because you weren't participating in a ruling. And I really wanted to ask the governor some of these questions, just about the process that she went through in evaluating her decision-making, how many people were at the table, was there diversity of opinion? My external perception, it feels a little like there was some groupthink happening with a lack of diversity at the table to signal that this is worth thinking about. Maybe that's not fair and maybe that happened, but I wanted to ask her a lot of these questions. So it's almost rhetorical to you because I don't feel like you can address some of the things that
I may be able
troubling
to,
me.
actually.
Well, if you want to speak to it, I'm
Sure.
still in that place of struggle, and I would love to hear
And I
it.
appreciate that, and I appreciate the care and thoughtfulness with which you're approaching your job. For better or for worse, I'm what might be called an experienced user of the JNC process. I've gone through it during 4 administrations: the Romney administration, the Patrick administration, the Baker administration, and now the Healy administration. Each time, that process, from my perspective, has been virtually the same. The first step, as you all know, is you complete a lengthy questionnaire, application, and you supply numerous references. That happened each time. The second step is to be interviewed by the screening committee. That happened each time. If you're recommended by the screening committee, you're interviewed by governor's legal counsel and by the governor and sometimes the lieutenant governor. That's happened to me each time. And frankly, I have a lot of confidence in this process because I think you see it in the quality of the judiciary that we have. And perhaps I'll just go into a little bit more detail because it might help. when I first applied to become a judge on the appeals court, it was during the Romney administration. I was recommended by Governor Romney's JNC for appointment to the appeals court. I believe that group consisted of more than 20 people, but I don't really, it was an awful lot of people to be interviewing a person at one time, so I didn't count. I applied again for a position, and that first time it didn't work out. I was interviewed by the governor's chief legal counsel, and then I ultimately was not appointed. I applied again, actually, at the encouragement of people who had been on the JNC during the Romney administration, because I actually would have been discouraged and not reapplied. But I was encouraged and I applied again for a position on the appeals court during the Governor Patrick's administration. Again, Governor Patrick had a large JNC. I don't remember the specific numbers, but it was a big room, maybe 20 people or more. I was again recommended by Governor Patrick's JNC. I then spent a number of years on the appeals court. I was encouraged after some period of time to apply for the openings on the Supreme Judicial Court at the beginning of Governor Baker's administration. And I did that. I was interviewed by Governor Baker's SJC-JNC, and I was again recommended to him, or recommended by that committee. I was interviewed by Chief Legal Counsel, I believe, the Lieutenant Governor and the Governor. I was not appointed. And this time, essentially, that entire process has happened again. So I understand your concern about the optics, but sitting from my chair, I have done everything like every other candidate. And I don't know what else I can do other than do the process that's been really in place since the Dukakis administration. So I hope that helps in some ways address your question.
How many people were on the current SJC, JNC?
How many what?
How many people, how many members did you interview with?
So again, I want to say it was like 5 or 6. The SJC, JNC, well, each governor gets to decide. The SJC, JNC has historically been a subset, although I don't know that every governor has made a subset or so. I mean, I haven't done a study. I can only tell you the ones I've gone through.
No, I appreciate that extra information about it. And again, I will say I am still in a place where it is not a clear reason to vote one way or the other. It's just an area that is troubling. It's troubling to me. Let's put a pin in that. Let's talk about some of the things we talked about. Actually, I had two issues I wanted to talk to you about. One was AI, which I think has been talked at great length tonight. Or it's not tonight yet, it just feels like it. So I'm going to leave that one alone. There were a couple things that haven't been discussed, but I think it's fair to say we've explored it. We talked about it, and I wanted to bring it to you again to give you an opportunity in this forum to talk about it. But the conversation that we'd had about reproductive rights versus reproductive justice, and just framing it as reproductive rights being the right to an abortion, for instance, although there's other things baked into reproductive justice like education and contraception and what have you. But reproductive justice being about access to it, right? So where marginalized communities or lower income communities may not be able to access what is a right, which then translates to an injustice. And I really liked what you had to say, and I'd like to give you an opportunity to address it again, because I think it speaks to who you are and how you think about things.
Right. So there are rights in the abstract, and then there are rights in application. And a right in the abstract is obviously very important because it's the legal foundation for the right. But people live the right in its application. And if they don't have the ability to attain the rights that are being protected, then it's almost as though the protection didn't exist. And I think that's the distinction you're trying to draw, and I understand that completely.
Yeah. And you'd also talked, when we talked about it, about just linking it to so many other areas where access versus, you know, you have a right to things, but if you can't access them from jobs and just income inequality and the marginalization of, you know, populations becoming more marginalized given access issues, which I think is I appreciate the way that
It's a critically serious problem.
that extends into so many different areas of life. No, I appreciate that. I will just close by saying that basically echo what I said before, that I can't conceive of someone who's more qualified and capable of immediately sitting down and getting to work. And that says a lot. And who you are and how you are in the world says a lot. So I very much just happy to have gotten to know you, and thank you for your time. I have no further questions.
Thank you.
Thank you, Counselor Jacobs. Last but not least, Counselor Ferreira.
Thank you, Governor. Thank you for driving all the way to Fall River, Massachusetts, and meeting me at the restaurant and spending time with me the other day. It was very appreciated. You and I had a lot of discussions. But speaking about AI in the room, that was my first thing. When I read that you wrote 900 decisions, I put your name in and said, you know, I wanted like a digest of what, and nothing. So you're safe so far. But I thought that was the way to go. Then I had to pull out Mass Lawyers Weekly and do other things. You and I talked a lot about some different topics. I'm the only sometimes cop in the room. You know, I was in law enforcement for 30 years. I've been a prosecutor. I've been a criminal defense lawyer since I retired 10 years ago. And I do some other things. But I shared with you my concern is that police can't or do not want to do the right job anymore. And you and I talked about some of the decisions from the SJC. And my fear is that our Commonwealth is going to suffer because of it. I believe there's a thin blue line that we talk about between anarchy and having an orderly society. And do you have any thoughts, like publicly, about decisions that have come down from the SJC or things that you see are a hindrance to police being able to do their jobs?
So I can't comment publicly on opinions of the Supreme Judicial Court. I follow all decisions by the Supreme Judicial Court. What I would say is the following. There's good and there are bad examples of everything. And it is important to remember that, particularly when, or not even particularly, when evaluating police conduct. The vast majority of police conduct is honorable and critical in our society. And as you mentioned, is essential to maintaining an ordered community. So I try to look at the cases, and this is, I think, particularly in the field of searches and seizures. You know, the touchstone for that is reasonableness. And so you look at the facts and the circumstances, and you look at that as it was presented to the officer at the time, and you take it from there.
During the last SJC hearing, I talked about, I had recently met with a police chief because I still associate with some of them. And he literally pulled out his phone and showed me, look, Joe, this is what was happening like 5 years ago. My guys would do 30 stops on average. They would do field identification cards for reasonable suspicion people behind buildings. And now they're all zeros, all zeros. He said, and I said, Chief, what are you going to do? You know, like, we want to hold our people accountable, make sure that they're doing their job. You know what he said to me? Nothing. If they don't do anything, they don't get in trouble, I don't get in trouble. And that's a problem. I think it's a problem. Do you think that's a problem? When police don't want to do their jobs or afraid to do their jobs?
Of course, but I also think there may be some misreading of some of the cases, and that maybe the best solution to that is some education so that the police officers perhaps don't feel or don't have a misunderstanding of what the SJC cases have said.
I can tell you that some of them think, like the Commonwealth versus Long case, is that, you know, if a person's of color or not white, they get a second bite at the apple to say, hey, I think it was a racist stop. even though I had a taillight out. And then they look back at the officer's records and see how many people he gave tickets to that were of color, how many reasonable suspicion cards he did, for the last 3 years. And if it's disproportionate, he's going to be labeled a racist, even though that person's not a racist. So that's the fear. And I think, and maybe you can comment on this, do you think sometimes the court goes above and beyond deciding the case in front of them and tries to create law from the bench, legislate from the bench?
Well, the SJC certainly has a broader, I would say, scope than the intermediate appellate court does. I can only really speak not in generalities. I can try to explain to you my own approach to cases. I am a judge who very much feels that you wait for the issues to come as they're presented in a case. That's the only way you really have the security of knowing that you have an adequate record and that you know the facts, because every case has different facts. And if you try to decide something without any reference to facts, you're going to be more likely to go astray. And that's not something I want to do.
Do you think there are cases that the SJC has decided that go above and beyond addressing the issue at hand?
Oh, with all due respect, Counselor, I'm not going to touch that one with a 10-foot pole.
I'm sorry, you're not going to what?
I'm not going to touch that one with a 10-foot pole.
Okay.
Some of them are sitting right behind me.
I think you're safe, they left. One of the things that we talked about is the new post commission. Now, I can tell you my 30 years experience in 9 as chief, like, good cops want good cops. Nobody wants bad cops. Nobody wants to live in a police society, but we need to be adequately protected. One of the things that came out of, and I was one of the first departments accredited, and I'm a big believer in professionalizing police work. The post commission, which I guess I'm a fan of, making sure that there's standards and training, but the way that they had to report officers' prior conduct for the last 20, 30 years is so disparate. Some departments thought, oh my God, I had to report this guy. And in my own old department, 25 years ago, somebody said, hey, a Red Sox player just drove through town. Everybody's on the computer, like trying to figure out, where Mo Vaughn is or whatever. They got disciplined. So literally, like on Facebook the other day, I saw people showing that these Somerset police officers were disciplined because they improper use of their data terminal. I know other cities, big cities, that reported like 1 or 2 officers in totality, where like small towns, I don't know if they read it wrong, but if I talked to the chiefs, they thought they were required to do all this stuff. So you got great police officers being kind of a smear campaign of something that happened 25 years ago, and other departments just didn't report it.
So I understand your concern, and I agree with what I think is the general principle behind your question, which is that consistency of application across departments is extremely important.
Do you think the SJC could have an impact on that at some time? You envision that outcome before you?
I mean, I don't know. I suppose anything's possible. And if it is, if I could envision it, then I can't comment on it.
All right. What do you think about the implications of like 1 free misdemeanor? So now we have like the city of Brockton, they want to bring in the National Guard to schools because these kids are just running amok.
So, Counselor, with all due respect, I'm a sitting judge, so I'm not permitted to comment on matters of public controversy.
Well, you could be asked someday to decide whether or not it's good law to allow people to have a free pass, right?
I could be asked to do that, and for that reason also, I would have to decline to answer the question.
But you answered other questions about abortion and things like that, right?
I don't think I was asked that question. I wasn't asked a question about abortion.
Do you feel like, what is your stance on reproductive rights?
Oh, I completely respect the law that we have in Massachusetts concerning reproductive rights.
Thank you. What about, I know my Counselor DePaulo asked you about the case about people under the age of, is it 21, getting a You gotta get eligibility for parole. Do you think that, could that violate the separation of powers?
I think the question in that case was whether a sentence for life without the possibility of parole violated either Article 26 or the Eighth Amendment of the United States Constitution. I think that was it was first posed in the Diachenko case, and it was secondly posed in the Mattis case. The first case, Diachenko, was with respect to juveniles. The second case was for this category known as emerging adults, 18 to 20. And I've talked so long, I actually lost track of your question, so I really apologize.
Do you think that could violate the separation of powers?
Oh, the decision? The
Yes.
decision doesn't violate separation of powers. But perhaps you're referring to the dissents, which there was at least one dissent that believed that sentences belonged to the legislature.
Correct.
And that it would violate separation of powers to reach a conclusion that the majority did. There are, starting with the Supreme Court, although I completely respect the legislature's role in setting statutory sentences, those statutes have always been subject on the federal level and the state level to constitutional review by the courts.
So back to Marbury versus Madison, the buck stops here.
Buck stops with the
Yes,
courts.
JC.
And well, at least with respect to the Constitution.
I want to read, I got a lot of letters about you. Most of them extremely favorable. A couple of constituents just want me to vote no because they don't know anything about you, but they just didn't think it was a good idea. But I did get one in particular recently that I was actually pleased to get. And just let me, I screenshotted it. So forgive me for 1 second.
Emerging technologies. I still don't know how to do a screenshot.
Screenshotted it. So this person I wrote to is the supervising attorney, the appeals unit of the Committee for Public Counsel Services, the State Public Defender's Office. I've worked here since 1980. I've represented criminal defendants in several hundred appeals, most of them in the appeals court. I've appeared before the Honorable Justice on a number of occasions. And he goes on to say wonderful things about you, how bright you are, how your decisions are thoughtful and extremely precise. They get right to the heart of the matter. On 2 occasions when I appeared before her, she asked me the dispositive question, not to my benefit, within the first 2 minutes of the argument. She was persistent in her focus, always courteous, and eminently fair. The part that I liked the most, which actually gave this more credence, was the end, where he said, I say this despite the fact that I never won an appeal in which he's written the opinion for the court. And this is Eric Brandt out of Brookline, but he said, in your 16 years, you have demonstrated the skills, the disposition, the judgment to be an obvious choice for the SJC. And one thing no one mentioned today is, and you didn't because you're so humble, you spent a few years at this university called Oxford and got a PhD in philosophy. How does that?
English.
English. Okay. Does that help your writing a little bit?
I don't know.
I think you're a wonderful person. I think every positive thing that people said about you today is true. No one talked about your violin yet either, but that was the end of our conversation. And what you said really struck a chord with me, no pun intended, but how, you're one of 20 violinists and everyone needs to be on note and do their job. And if the whole orchestra does that, it's a beautiful thing. And I think that's true about society. And that's, I think you kind of said it like that. Like if anyone in society does their job, we'll all be fine. Stay in your lane. I think you're going to make a great justice on the Supreme Court. And I am honored to meet you. I am confident you're going to do a great job and do it right. And you're not going to be a shrinking violet in the room either.
Thank you very
So-
much, Counselor. I hope I earn your praise.
Good luck.
Thank you, Counselor Ferreira. I think we have one more question from Counselor Devaney. If there's others, please let me know and I'll be happy to recognize you.
One thing that wasn't mentioned, and I think it's important, that you bring 33 years of legal experience at the age of 63 to the SJC. And what is most important to me, you bring life experience to the SJC. And I look for qualifications and experience, but I absolutely look for compassion, and you have demonstrated in all your years. And I met you, I presided, I voted for you 16 years ago, and you earned my vote again. Thank you so much.
Thank you, Counselor.
Thank you, Counselor Devaney. Not seeing any other hands for questions. I think that concludes today's hearing, and that means everyone survived till after 2 without lunch, which is always a good sign. I want to thank Justice Wolohojian, as well as all the council members, and look forward to our upcoming nominations vote later. Thank you.
Thank you.